Ladies and gentlemen, good morning. Please be seated. Because of this hearing this morning down in southern Nevada, we used to have 2 trees. We now only have 1. We are here on rules of civil procedure, which harkens me back to days of law school. Having said that, this is an important issue. It's something that we are trying to get right. I applaud both Justices Pickering and Gibbons and their committee members for attempting to come forward with reasonable revisions of this rule. Today we are here to talk about those rules and possible further tweaking of those rules in some cases. With that, any remarks from Justice Gibbons or Justice Pickering as to this?
I guess I'll go first. Thank you, Chief. First of all, I want to echo your comments and thanking our committee members that worked on this. It was about a 1.5 year project, and we were meeting on a very regular basis, plus had subcommittees as well. And I know we have a number of those committee members here today. If I could just point them out and that they stand and just acknowledge them. But over on my right side, we got Commissioner Bonnie Bulla from the 8th Judicial District, Rachel Mestel from Las Vegas Attorney, who is our family court representative and helped us a great deal with the committee. I see Judge Alyssa Kadish there in the back, and Alyssa was in charge of our, I guess, Rule 4 and some of those other subcommittees as well, like very technical stuff that you appreciate. Behind Judge Kadish, we have George Bochanis and Don Springmeyer. And again, George and Don helped us with the class action, Rule 68. George did Rule 35 and some of the other discovery rules as well with that subcommittee. I want to thank all of you for your efforts and all as well. The only other comments I'd like to make is that this is being videoed in Carson City, so we'll probably have some members of the public that would like to speak over here in Carson City. We did receive a lot of public comments, and we do appreciate it. We read all of them, and I've kept them all here. I have them up on the bench if anybody needs, we have to refer to them at all with any of the commentary today. One of the rules that we had the most comments on was Rule 35 for medical examinations, and the comments were mostly directed towards psychological medical examinations. I want to tell people who are concerned about that, all those comments that came in were distributed to all the justices. They also were distributed back to the subcommittee that was drafted that rule, and in taking those concerns that were raised in those comments, the subcommittee is proposing some additional language that they plan to submit to the court after the hearing today. So I just want anybody that's interested in that issue to know that we're concerned about it, and we will try and fix those concerns the best we can to address the concerns of the psychological providers and professionals as well. I'd also like to say that our last major revision on the Rules of Civil Procedure was in 2005, so it's 13 years later. Since 2005, we've tweaked some of the specific rules, but we were able to go through Rule 1 to Rule 85. What was the last? I forget the last one. So we went through all of them and addressed every one. And the court's very concerned about changes in technology and all that have happened in the last 15 years. And so we're trying to take that into consideration and with these rule drafts as well. So with that, Chief, maybe we can hear from members of the public and see what they think of Justice Pickering.
I don't want to take up the time that we've allotted today on members of the public, and it may be that we will not complete the comment period today. This is a sizable undertaking that this committee has worked on. I really echo Justice Gibbons' comments on thanking the committee. The committee membership has put in probably hundreds of hours, every single person on that committee. I can't see the courtroom up in Carson City, but we have had representation from the north as well as from the south, and valuable input not only from the committee members and the subcommittee members, but also from the public. There is a public website on the AOC page on the court system, that allows you to see access, gives access to every one of the committee minutes, which are beyond the advisory committee notes. It shows the depth and extent of the debate that went on this. I can't be more proud. This is not a perfect work, and that's why we're here today and going forward having public hearings on this, but this is a monumental undertaking, and without the committee members and their hard work, we would not be in the position we are today. So thank you very much, and thank you so much to all of you who submitted comments. We're better than each of us individually when we work as a whole, and that's what this committee has managed to do.
Thank you. There are 5 of us in Las Vegas today. Justice Stiglitz is in Carson City, holding the fort down there. Justice Perry is unavailable, but he will listen to the comments before we issue our final rule as to what we're doing with this. We'd like you to try to keep your remarks kind of curt and to the point. As much as I have to say 3 minutes, I'm going to say 3 minutes, and then we'll plus or minus you depending on where you're at with your comment, so that everyone gets an opportunity to speak. With that, Madam Clerk, if you want to start down the list for signing, for speakers. Justice Stiglitz, while our clerk is looking at our sign-ins here, roughly how many people do you have present in Carson City this morning?
There are 8 people present. I'm not certain if they all are intending to speak, but there's 7 who are signed up to speak.
All right, thank you.
I was counting Mr. Reese as a person.
That's up to you.
Let's just keep doing it.
Good morning. This is a significant undertaking, as you described, and we generally, James Jimerson on behalf of the Jimerson Law Firm, I apologize. Our firm is generally in support of the Nevada Board of Governors Task Force recommendations concerning the proposed amendments. I am here today to speak specifically as to the proposed amendment concerning Rule 26B1, the proportionality addition or revision as to the scope of discovery. While the federal courts have seen fit to incorporate a proportionality analysis into the scope of discovery, I believe that is unwise. I believe that the default rule should be that the scope of discovery goes to the merits of all claims and defenses, period. That's what justice is, the discovery of the truth. And if we were to perform an analysis at the very beginning as to what is convenient, what is cheap to get access to, it may curtail the search for the truth. Conversely, the costs of discovery have increased dramatically. With technology, electronically stored information, it is a very real concern. The current rules provide for protection of parties that need the court's intervention to protect them from the rising costs of discovery. There is already the ability for the parties to seek a protective order to prevent the costs of discovery from exceeding the value of the case. Most of the time, during your early case conference, proactive counsel will know what the potential costs of discovery can be and can address it early on to perhaps limit the costs and to reach agreements with the other side about how to best and most efficiently approach discovery. To put a proportionality analysis in the scope of discovery would encourage a delay of that conversation, would allow the parties to say, well, we all know what the scope of discovery is. It's supposed to be proportional to the merits of the case, the amount of dispute, and the public policy, the issues raised. We're just going to put that off until requests for production are served and certain costs are realized at that point. That isn't the best approach. The best approach would be to attempt, knowing that the scope of discovery is, as it currently is, into all matters relevant to the claimed defenses. It would allow and encourage those parties and practitioners to address these matters as early as possible. In so doing, you would then, to the extent an agreement can be reached, a joint case conference report to limit certain areas of discovery or to tee up any issues that would need to be addressed in a motion to protective order. To change the scope of discovery would be to change our default rule, which is to allow for the discovery into the merits of all claims and defenses. The default shouldn't be a proportionality analysis. Thank you.
I have a question for Mr. Jimerson.
Go ahead.
Mr. Jimerson, I've long advocated for a process that involves and requires trial judges to undertake the responsibility of issuing scheduling orders, and in that process conduct early case conferences with counsel and, in most instances, the parties within 90 days after the filing of a joint case conference report. At those conferences, which are taking place routinely in Washoe County and most of the judicial districts throughout the state, the parties agree on the proportionality and the nature of discovery and a variety of other issues, including testimony of witnesses and experts and the like, all of which then becomes part of the scheduling order. This is not unlike what takes place in federal court. From your remarks, I infer that this is a process you would endorse.
Yes, I believe that the best practice would be to address such issues as early as possible in order to stave off some of the dangers of exorbitant discovery costs.
Thank you.
Thank you.
Ryan Lowe.
Good morning. I'm Ryan Lauer of the Morris Law Group. I'm here on behalf of the Litigation Section Committee of the Nevada State Bar. We submitted comments on October 12th, generally supporting the rules, and I just wanted to be here in person to say, subject to our comments, we support the amendment, and we hope you consider that and pass that subject to our comments. In my individual capacity, I also support them and believe that anything we can do to be closer to the federal rules, where there's additional case law, other people looking at the same kind of things, I think it's more efficient, which goes along with Rule 1 of the civil procedures to be efficient, just, and speedy. Thank you.
Thank you.
Bonnie Gula. Good morning. I will certainly be happy to address any questions you may have, but I'm going to take capacity at the present time.
Thank you.
Montgomery.
Good morning.
Good morning.
My name is Montgomery Peck, and I'm a shareholder with Littler Mendelson. I appear at this public hearing today to speak about one specific proposed amendment to the Nevada Rules of Civil Procedure, namely the proposed NRCP 23D2. In relation to 23D2, our firm has also submitted written comments for your review last Friday, October 12, 2018. We submit that the addition of the proposed NRCP 23D2 would radically change existing class action rules and arguably create a new exception for class representatives that has no equivalent in Federal Rules of Civil Procedure 23 or its related body of case law. As the committee is aware, existing NRCP 23 governs class actions. Like FRCP 23, the rule upon which NRCP 23 was directly modeled, NRCP 23 subsection A has 4 essential requirements for the maintenance of class action lawsuit: commonality, typicality, numerosity, and adequacy. Class action case law dictates that any class action failing to meet any of these requirements is subject to decertification and dismissal of class claims. Like other jurisdictions, Nevada looks to the body of case law surrounding FRCP 23 for guidance in determination of class certification. Under both FRCP 23A4 and NRCP 23A4, a class action representative is held to a higher standard than a regular plaintiff in a single plaintiff case. Indeed, a class action representative must fairly and adequately represent the interests of all class members and often receives enhancement payments in recognition of this heightened role. Proposed NRCP 23D2 negates existing NRCP 23A4's class representative adequacy requirement by removing a court's ability to decertify a class action due to the inadequacy of a class representative. Indeed, proposed Rule 23D2 forces a court to replace a, quote, unable or unwilling class representative with a new substitute. This proposed rule will undoubtedly lead to arguments for a bulletproof class under the adequacy prong under Rule 23A4 and completely separate Nevada from existing class action case law in this regard. Further, without any analogous rule of case law, Nevada courts would have to grapple with the permutations of this rule and various interpretations of the terms used therein. Without any advisory committee notes for guidance, the proposed amendment to NRCP 23D2 begs the question why. Why is such an exception necessary to the long-standing rationale of one of the pillars of class action law? Why should Nevada create an exception to the adequacy requirement that would lead Nevada courts to create completely new standards under NRCP 23D2? As noted in our written comments, the use of offers of judgment in the class action context continues to evolve in recent U.S. Supreme Court cases like Genesis Healthcare versus Simzik and Campbell Ewald Company versus Gomez. These are complex issues, and creating an exception to NRCP 23A4 likely has many ramifications that are not fully understood nor have been addressed by any existing case law. We assert that existing NRCP 23, like its federal counterpart, FRCP 23, requires no such unnecessary exception. Whereas much of ADKT 522 has focused on conformity with FRCP, this proposed rule stands in stark contrast by creating a massive distinction to FRCP. Along with our submitted comments, we respectfully submit that proposed NRCP 23D2 should be excluded from any amendments to the NRCP. Thank you.
Thank you. If we could, Justice Stiglitz, can we get the first three folks in Carson City who wish to speak?
Certainly.
Let them speak.
Maybe you'd like to give public comment? Come forward. Mr. Silverman? Sorry. Mr. Galloway.
Good morning, Chief Justice Douglas and members of the court. Graham Galloway, Chairman of the Discovery Rules Subcommittee for the NRCP Committee. I've read the comments, public comments the court has already received, and I wanted to address a few of those. And I wanted to start with Rule 35, since that's the rule that we spent the most time on. The subcommittee is the author of option number 3, or option number 1 and 2. There's 3 options that have been presented to the court or alternatives, and the subcommittee is an advocate and is the author of alternative number 1. When I first started practice in the personal injury field, the Rule 35 exams, at least in the personal injury field, were termed IMEs, independent medical evaluations. Over the years, this has been transformed. Advocacy, gamesmanship, bias, and money have transformed this process into something that I call a BME, a biased medical examination. I deposed a doctor several years ago who does hundreds of examinations every year, earns over $1 million on these examinations. There are problems here. A change is necessary, and if you need any further illumination, I think you could ask Commissioner Bula how many times that she has to deal with this issue on a weekly basis. If you need further illumination, Judge Tim Williams down there in Clark County authored a decision in Wilson versus Young that sets forth the problems that we face on a daily, regular basis now with Rule 35 exams. The comments that were made, one is that we don't follow the federal rule here, and that is correct. But if you look at other states, and George Bochanis of the committee and the subcommittee did a survey, there are states who allow audio recording of these exams, states that allow visual recording of the exams, states that allow observers, and states that allow the plaintiff's attorney to be present during the examination. So what we're proposing in option 1, alternative 1, audio recording and observer status is not something new. A second comment was made by the Board of Psychological Examiners. Members of the subcommittee have proposed a draft or a explanatory note, a drafter's note, I think that addresses most of their concerns. The third criticism or comment was that somehow the changes being proposed in alternative 1 or option 1 somehow unlevel or unbalance the playing field. For anyone who says that to you, I suggest that you ask them a very simple question. Are they willing to allow their client to be interviewed by someone from the plaintiffs that the plaintiff designates for an hour without the attorney being present? And you know the answer is going to be no. This is what we face now all the time with these Rule 35 examinations in the personal injury field. The examiners are not just conducting physical examinations, they are actually conducting cross-examinations and then distorting what has occurred. So the proposals in option 1, we believe will put some balance in the process and level the playing field, not unlevel. On 16.1, there were 2 criticisms. One had to do with a drafter or explanatory advisory note that the subcommittee proposed with respect to the definition of reports required under 16.1 in the premises case. And the definition includes standard documents that are required to be produced no matter what. Incident reports, accident reports, sweep logs, inspection logs or inspection reports, the videotape of the actual incident if it exists or soon there or soon before what happens or shows the area of concern right before an incident happens. These are documents that should be produced. The response or the criticism is that why produce them in the 16.1 arena? Why don't you wait for a interrogatory or request for production? But there's no reason to delay this. And that's what the opposition on that particular point is simply saying, let's delay the discovery of these documents and exhibits. And there's no rationale for that. A second criticism was the treatment of non-retained experts, the treating physicians. That's been a hot topic. It was the topic of that FCH1 case that the court decided a year or 2 ago. And what we did was simply take the existing advisory and drafter's note and put it into the rule. So this is not a new provision, doesn't change FCH1, doesn't change the existing law. We just simply shifted the drafter advisory note and put it into the rule to give it some punch, to give it some effect. Rule 32, this is something that I personally proposed, and it has to do with using the videotape or deposition transcript of a treating physician or any expert for that matter. I borrowed this. This came from the California Code of Civil Procedure, and I hate to use California as an example, but I've practiced there for 34 years. This is an excellent provision. It doesn't raise the cost of litigation as has been suggested. In fact, it lowers the cost. It works perfect over there. And if there's any issue or concern, you simply need to talk to the people in California. They'll confirm that this is a workable change in the process. Finally, on Rule 45, we've suggested a notice, that's the controversial provision here, a notice of a subpoena before it is issued, a subpoena ducis tecum is issued on third party for documents. This comes up in the medical area, the personal injury area again, and the common practice, the standard practice now is that a letter goes with the subpoena telling the target they can produce the documents before the notice deposition. Typically what happens, they produce it right away, and then the other side doesn't have an opportunity to oppose the production of those documents. We believe that this short, brief period, a 7-day notice, is not a burden on the system, and it won't clog or drag down the process. We believe that the changes being proposed by the subcommittee on the discovery rules, as well as all of the rules, move us forward, make us better, make it more fair. So I would urge the court to adopt the rules as we have recommended. Thank you very much.
Thank you. And one more speaker in Carson before we shift back down to Las Vegas.
Mr. Silverman?
My name is Gary Silverman. I'm speaking as a practitioner of family law. I do not speak on behalf of the family law section. As a family law practitioner, my goal is a prompt and informed resolution of a case to reduce the cost of litigation to citizens and unburden the courts. The predicate assumption is that no case will resolve if there is an imbalance of information between the parties. Both parties have to believe and understand that they know as much about the case and the other side's case as the other side knows about their case. The rules are the mechanism by which that information is transferred. They are the device, in large part, that facilitates resolution. Information needed to accelerate settlement and resolution. Information is needed to accelerate settlement and resolution. That information should be transferred in specific ways. Make the parties articulate certain kinds of special claims in family law cases. Do they have a separate property claim? Those should be articulated. Those should be specifically pled. Waste claims should be specifically pled. Custody claims should be specifically pled. Property claims arising from cohabitation. And secondly, make the parties disclose accurate, comprehensible information as to their income and expenses. A, require specific pleading in the 4 topics I've just discussed, and require that accurate and comprehensible information as to income and expenses be transferred to each party as soon as possible. It's argued that such pleading rules will just engender motions to amend. They should not. A lawyer who does not ask her client the simple questions that put the lawyer on notice of those 4 issues needs to find another area of law in which to practice. It is not difficult to ask your clients the facts that would be the basis of those areas of special pleading. Making parties articulate why they want custody and how it is really in the child's best interest and not simply in the interest of the client's ego or pocketbook will lead to infinitely more and faster settlements. 16.2 information is the most valuable information we get in family law cases, especially income and balance sheet information. What do the parties own and what do they owe? And how much do each of the parties earn? If that information plus specific claims is made clear, lawyers can shape and streamline their case, and the court, especially in dealing with pro per parties, can effect fairer, faster settlements. Good rules are thwarted, if not defeated, by bad forms. The financial declaration form is difficult and confusing to lay litigants as well as lawyers and their financial paralegals. Hire the forensic accountants who have been serving lawyers in Nevada for these last years, many years, and ask them to revise our forms. Perhaps to even create 2 forms, one for complex cases and one for less complex cases. There's a wealth of experience and information in the expertise of the forensic experts. There's about 4 or 5 who really deal with the entire state. who can help us improve those forms, and we should pay them to do it. Do it when all their other work might be set aside. We should pay them and ask them to do the best job they can. Funds are available in the American Academy of Matrimonial Lawyers treasury, and funds are available in the family law section treasury. I don't know, I can't say that those will be offered or tapped, but they're available, and I believe would be offered. Finally, judges are reluctant to sanction parties for 16.2 failures. Those failures muck up the system, slow everything down, and prevent resolution. Make rules which require the judges to make the transfers of information in 16.2 fast and accurate. No one likes sanctions, but the alternative for the judges, the lawyers, and the system is worse. Finally, if this request sends you back to the drawing boards after a year of work, you'll have very little thanks or appreciation, even from the family law bar and the thousands of Nevadans whom you will have helped. I thank you for your efforts, recognizing that no good deed goes unappreciated. Thank you.
Thank you.
Thank you. We'll shift back to Las Vegas.
Dr. Sharon Jones-Forrester.
Good morning. Dr. Sharon Jones-Forrester, thank you so much for the opportunity to speak with you this morning. I'd like to address Rule 35 and specifically to speak about the issue of bias. In my profession, and I would argue in all of the professions, it is a commitment to science and a commitment to ethics that allows us to most efficiently, effectively, and consistently guard against bias. Therefore, when I am in practice and throughout my profession, I must rely on what the science tells us is the best possible practice. The science has consistently shown that allowing audio or video recording of examinations or live in-person examinations consistently compromises the validity of test results. This has been shown throughout many scientific studies, leading our ethical bodies, including our federal APA ethics code, our state code, our state licensing board, and our state professional association to say psychologists and neuropsychologists must guard against allowing audio or videotaping or live in-person observation because it can compromise the validity of our data. That commitment to science and commitment to ethics also allows us to be very careful about the extent to which we may be pulled to be advocates. I do a significant amount of forensic work and work with two patient populations for whom this could pose a very significant risk to public safety. I work with active duty military service members who, as a result of injury, have been put on do not fly status. They come to me for an evaluation. I then have to make decisions about whether or not to grant aeromedical waivers or to opine as to their ability to return to active duty. If the validity of my results is compromised in any manner, that could have significant implications, negative implications with regard to their safety. The other patient population I work with frequently in a forensic context are individuals facing capital or non-capital murder charges. Certainly, when I'm asked to opine and render an expert opinion to the court based on my evaluation, validity and accuracy is key to the public trust in terms of jury presenting to juries what the facts are, what the findings are of the evaluation. And certainly, when I render an expert opinion to the legal finders of fact, they need to trust that I am doing everything I can, guided by the science and guided by my code of ethics, to ensure the accuracy and validity of my findings. I strongly believe that allowing third-party observations consistent with the science would significantly compromise my ability to render an opinion that is based on best practices, on what the science tells us is the appropriate action, and what my own code of ethics guides that I do I thank you so much for the opportunity to share my concerns about Rule 35. I would welcome any questions, but I just wanted to say that really ultimately in conclusion, science and ethics is our best possible protection.
What's the length of your observations or examination of the capital, non-capital murder case? Defendants. What's the length of your examination usually for capital, non-capital murder defendants?
I typically do about 6 hours of testing and then an additional number of hours of clinical interview, records review. So depending on the case, that can vary pretty significantly. In a capital case, it's not atypical for me to spend 30 hours plus additional hours in reviewing the science, reviewing the literature.
And do you have an idea of how many times you've testified before finders of fact?
I have testified 7 times on capital and non-capital cases, including post-conviction cases.
And what about the military cases? That interests me.
The military cases, because we have very few clinical neuropsychologists here, in most jurisdictions, military cases are handled within the military. Because we have very few providers, they're often referred to us as civilian providers. So although I'm a civilian, a great deal of my work is with active duty military folks. In that context, the military has their own internal, what's called a medical evaluation board. When they refer out to me as a clinical neuropsychologist, I would conduct a full day evaluation. That ranges typically about 6 hours of testing. I then report back to the military, back to whatever particular treating provider has referred to me, to opine as to the extent to which there may be deficits from an injury, traumatic brain injury, post-traumatic injuries are quite common. And then what's called polytrauma, which is when traumatic brain injury and post-traumatic stress disorder co-occur. In that context, I'd see someone for about 6 hours, draft a report talking about the conclusions and summarizing their test data, and then that medical evaluation board, in this case at Nellis Air Force Base, would have to render a decision as to the person's ultimate dispensation about ability to return to active duty, ability to fly, and so forth.
So your Rule 35 would have no audio or video, no third-party observation, no live in-person examinations?
That is correct, and that would be very consistent with our own code of ethics and also with what the science tells us about the fact that third-party observation globally, either audio, video, or live, has been shown to skew and in some cases invalidate test data, thereby compromising our ability to opine as to someone's safety to return to flying.
You're talking strictly about psychological examinations, not medical examinations.
Psychological and neuropsychological.
Not medical, though.
No, no.
Thank you.
Thank you very much.
Let me just add that and I thank you for coming, your insight is really helpful. These are rules of civil procedures, so they would not apply in the criminal evaluation context.
Of course. My concern about that, and I absolutely appreciate you bringing that up, my concern about that is precedent, and to a certain extent we have to, I think, always be just very aware that while it certainly wouldn't apply at this juncture, it could potentially create down the road impacts that could be
And your point about it invalidating test results crosses those lines. But I just wanted to assure you that this is...
absolutely, and thank you so much. I really appreciate that.
You heard Mr. Galloway, I presume, from Reno comment.
I did.
I'd be interested in your point of view about his objections and concerns as an attorney who's represented injured folks who had apparently different experiences than what you're claiming are or contending are best practices.
Absolutely, and I actually really appreciated his comments this morning. Bias is something that I think we all as professionals, certainly as mental health professionals, as legal professionals, I think we all have to be constantly vigilant about this issue. The reason that being guided by science and ethics is so important is that I myself would not allow audio or video recording that would compromise the data. When we talk about the potential financial reward, I would also not respect my fellow colleagues who would allow something that our own code of ethics and our own science guards against. And so definitely being cautious being clear in our communication cross-professionally is critical. But when we know that the science clearly states this compromises validity, when our own code of ethics absolutely unambiguously allows us or guides us to guard against it, then I would argue that my colleague in the North using the term biased medical examinations, I agree with him to the extent that allowing something that our science and code of ethics guards against would reasonably guide us to question that practice. And I would say that the best, being guided by science and ethics is the best way to guard against bias in all directions. And so I think that being extremely cautious about those practices, regardless of what side ultimately the expert is hired by, is the best course of action.
So your version of the rule would, as Justice Cherry commented, would bar audio and visual videotaping.
Yes.
And observers.
Yes.
But how does one test the ethical opinion and the approach taken by an expert in an area where bias is called into question?
And that's where I really appreciated our state Nevada Board of Psychological Examiners actually talking about the emphasis on public safety, that my professional license is granted by this organization, and this organization has explicitly said allowing anything that could compromise validity and compromise the ultimate utility of test data is profoundly problematic. And so being guided by my own code of ethics and my own licensing board, who has said that ultimately when we complete our training, when we become licensed, we have to be constantly vigilant that we are acting in the utmost ethical manner. And that includes protecting any practice that would undermine test data, test security, and the ultimate accuracy of our findings. That's my responsibility as a clinical neuropsychologist who's licensed in the state of Nevada.
Forgive me, I've been trying to wade through all this paperwork, and I've seen a number of comments regarding Rule 35, but does the board have explicit regulations where it adopts those ethical standards, and have they disciplined professionals for violation of the use of those standards?
To my knowledge, now, because Rule 35 certainly is a new proposal that we have, that we're just currently opining on, I do know that there have been any number of sanctions if there is an ethical violation of the federal ethics code or of Nevada rules and statutes. But as to Rule 35 specifically, I am not aware of any specifics in that regard.
My question was probably poorly worded. I was wondering if your board has adopted ethical standards that prohibit the use of video and observers.
Yes, and actually that was submitted, I believe, as of the 12th or earlier. The Nevada Board of Psychological Examiners actually posted to the Nevada Supreme Court their position on third-party observers or the proposed changes to Rule 35. May I quote directly? It's very brief.
Sure.
Okay. What they asserted in that position is, quote, in the interest of protecting the needs of the public, it is the position of the Nevada Board of Psychological Examiners that allowing third-party observers, monitors, and or electrical or electronic recording equipment during psychological and neuropsychological evaluations poses a significant threat to the public safety.
Okay, thank you.
End of quote.
Thank you.
Any other questions?
No.
Thank you very much for the opportunity to speak with you. I appreciate it.
Our next Las Vegas speaker, please.
Hello, I'm Dr. Thomas Kinsar. I'm a clinical neuropsychologist. I haven't been able to review some of the proposed changes to the the Rule 35 proposals that I read. I don't know when those are going to come out, but let me go through some additional things that Dr. Jones-Forrester to kind of highlight some of the issues that I have. First, I want to state that I fully understand how the presence of a third party at a medical examination might be desired. And in the case of routine medical examinations, may be perfectly harmless to the exam results. However, if the court finds useful the contribution of psychology and neuropsychology that we've made to the judicial decisions, there's reasons why in the case of psychological and neuropsychological evaluations we must proceed with extreme caution. There's really four broad reasons why we can't ethically allow a third party a recording of video. Number one, the presence of a third party in the diagnostic clinical interview portion will derail and invalidate the results because we know that there's good reason from research to believe that the examinee modifies their self-disclosure during the diagnostic evaluation, and they alter their responses in the presence of another individual or in the response of a camera or in the response of a microphone. And that will skew our results. Another reason, the presence of a third party, the requirement for standardized administration is not met because the measures were not standardized with a microphone present, with them knowing someone else is listening in, or with another individual in the room. The third reason is based on research investigating the effects of third-party presence. It's well known that performance on neurocognitive measures changes significantly. And we see changes in memory, executive functioning, attention, all in the presence of the person knowing someone else is listening in or that they're being recorded in some way, in some fashion. Responses to personality tests and answers to highly personal information may change considerably when they're being monitored, either by an individual or by a video or audio. The presence of third parties in examination rooms breaches the security of protected measures of psychological and neuropsychological processes, creating a broad concern for social harm. And related to this test security, number one, test development costs are enormous. It sometimes costs millions of dollars to standardize and norm some of the measures that we use for intelligence and memory and cognition. And the follow-up national norms that we use. When these measures are leaked out to the public and to non-neuropsychologists, the measures lose their validity. Another reason psychological measures are protected by state and law and professions are in professional ethics for a reason. By placing tests in the hands of those not obliged to protect it, the validity of the examination is destroyed, and the risk for the exam questions getting to the public would be high. In fact, it would only be a matter of time. Number three, another reason, measures to detect malingering and exaggeration need protection. Research consistently finds that between 30 and 40% of examinees seeking compensation for alleged injuries fail performance validity measures, suggesting an effort to appear more impaired than they are. The neuropsychologists are the holders of these protected measures. These measures involve empirically derived techniques that access narrowly defined cognitive processes that are known to remain preserved even in severe brain injuries. The names of the tests I use for this investigator are not even placed in my report, primarily because I don't want unscrupulous individuals researching them and then looking at how to respond on those measures. Allowing third-party observation and recording will expose these protected measures. The last reason is public safety. Neuropsychologists are often asked to assess high-risk professionals, including airline and active duty fire pilots, physicians, police officers, and high-clearance government officials who have been ordered to undergo neurocognitive assessment, often because of some concerns regarding their fitness for duty. Knowledge of the test items on a memory test or a measure of frontal lobe functioning could result in test results that might release this individual to duty or prematurely in cases where they might pose a risk to others. And for this reason, test protection is a matter of public security. And my final point is that the present system of exchanging test data between experts works. When raw data is turned over to another qualified psychologist or neuropsychologist for review, both sides can enjoy a full understanding of the strengths and weaknesses of the conclusions without jeopardizing test security and without invalidating the examination itself. There's no clear and persuading reason to alter the existing system that would justify the profound consequences that might result from adopting the proposed changes, at least as they pertain to the role of psychologists and neuropsychologists. Demanding a third-party presence places our profession in a great dilemma, a dilemma for which the only solution is to remove ourselves from the evaluation process in these cases. To do otherwise would violate ethical principles that we must adhere to and would breach security of protected test measures. Adopting any of the proposed options will result in the loss of psychologists and neuropsychologists in many judicial proceedings and from their role in many other matters pertaining to the public safety. For example, pilots, police officers, parental custody evaluation issues, competency evaluations, etc. For these reasons, I urge the court to reject the proposals outright. Thank you.
Any questions?
Chief, can I make one point of clarification here? There's been a lot of discussion of video. Video is not in the rule. The proposed 35 alternate 1, which the committee approved as a negotiated compromise. Video was discussed. It was on the table initially. Part of the negotiation process was video was removed. So I understand you object to audio for the reasons you said and everybody else said, but that video is just a non-issue. So the court's not proposing or considering video.
Good deal. Thank you.
Okay.
What about third-party observation on a claim of PTSD?
Well, again, when part of what we rely on as psychologists when we're doing a PTSD evaluation is the development of rapport and a sort of a container in which very private information can be divulged by the examinee. In many cases, when we do a PTSD evaluation, for example, we're not just testing that incident and PTSD symptoms. We're looking at the overall individual, which may include history of, substance abuse, history of abuse, their current relationships, stressors that they were facing when they were going into the, the incident that might have caused PTSD. And what happens is when you allow someone else present, whether it be a family member, or just the presence of a microphone and they know that their voice is being recorded with everything that they say, people change their behavior. They start not disclosing information that they would otherwise disclose just to an individual that they feel some privacy with. Even though on some level they know some of that information will end up in a report, there's a safety in that buffer that they don't get when they know they're being recorded or when they know someone is present. And based on what I read here, it looks like the individual, the examinee, can help choose an individual to witness or to be in the examination. And my concern is if the individual chooses a parent or a spouse, what if that spouse is the perpetrator of abuse? Do you think they're going to tell me that they're being abused if the individual's sitting right in the room? They might not even admit to abuse if they know they're being recorded. I have individuals who haven't told anyone. In fact, not long ago I had a lady who was in her 80s, and she told me I was the first person she ever told of her sexual abuse as a child, and she's never told her husband. And that can only occur within the safety and the confines of trust and an evaluation that's perceived as just between you and the examiner. Once you end up with a microphone, or they know that they're being recorded and that their voice is there, the people start pulling back. And you also get individuals who may act differently because they may play things up in the presence of a microphone or another individual in the room. It skews the results and it invalidates it. And it makes it just about impossible for us to feel confident that what we have is what is as close to what we should be getting during a private conversation.
If you're retained as an expert, hi, I'm Jim Hardesty. If you're retained as an expert in a case and asked to do one of these evaluations, is it your practice to release all of the information that you've obtained in the course of your interview and share that with the other side?
That would go directly to an expert, on the opposing side's expert, yes.
And your practice is that routinely is exchanged?
It is routinely exchanged. We typically exchange between experts, and as long as the individual is a psychologist or neuropsychologist, the information, including all of the notes from the interview, all the raw data from the testing, go directly to that individual for evaluation, and they go through it and render an opinion on it.
Have you ever seen instances where there's been court fights precluding the release of certain information to the other side?
Only when the information is being asked to be released directly to the attorney himself or herself. And in some cases, I could see where a psychologist might have difficulty releasing raw data to someone who's not a neuropsychologist who has the same ethical and legal requirements to guard the test data. So, for example, if a psychologist has to release raw data to a medical doctor, there might be some issues there.
So what do you do in those situations where your side of the case is represented, the other side of the case is represented but lacks funding to be able to secure their own psychologist to exchange this with? How does the other side in the pursuit of justice evaluate your notes, your interviews, make an assessment of your opinions?
Well, I think that the attorney would have probably rights to the notes of the interview. I think when it comes to the raw data of the test material itself, that's where we start running into a problem, because over time what we're concerned about is that every attorney's office is going to have file drawers that have all of our test material and questions and IQ stuff there for their use, and it is now in the hands of someone who doesn't have the same obligations that we have to protect it. You know, we protect it in our office, we lock it up at night. It's protected test information. And we're concerned that if that's released directly to someone, that it'll eventually be misused. And in terms of what I would do in that case, I'm not sure. I think that does present a problem. I don't know how often that occurs. But I think that could complicate things. So.
Okay, thank you.
Anything else?
Thank you very much.
Additional from...
Good morning, Your Honors.
Morning.
I am here not on behalf of the section, but I did ask for comments, and I have discussed things with a number of the sections, so I am here to answer questions and to provide some information from some members of the section as to their additional opinions on this matter.
Could you comment on Attorney Silverman's comments?
I do intend to do that, yes, Your Honor. The first is that on Mr. Silverman's comments, I am actually the one who suggested there might be increased motions to amend. The problem with specific pleadings, quite candidly, is that a lot of clients don't understand separate property to begin with. They don't understand marital waste. Sometimes these things are discovered much later on in the discovery process, which requires us to either front-load discovery when settlement could occur early, or to have to file motions to amend. Even if you ask the questions that Mr. Silverman proposed, do you have any assets before marriage? Have you inherited anything? I can't tell you how often we go through in my office, what assets do you have? What houses do you have? What real property? Is there anything else? What bank accounts do you have? Whose name are they in? Do you have retirement accounts? Do you have this? Do you have that? And 3 or 4 months later, we're producing documents, and suddenly I have a title to a piece of land that the answer I get is, oh, well, I didn't really think about that one. I haven't done anything with it in 25 years. I just discovered the deed when I was looking through documents for, bank statements. It was stuck in between 2 things. Okay, well, now I have to file a motion to amend on a piece of property that somebody didn't think about in 20 years. With marital waste, I actually have a case right now in district court where we were going through discovery documents, and suddenly found out because there were statements that my client didn't have access to, and suddenly it's like, well, where are these charges from? Well, now I have to file a motion to amend to add a waste claim. Legal Aid has also posited their concern with the specific pleading aspects. There are a number of self-represented, according to Stephanie McDonald, who for Legal Aid runs the Family Law Self-Help Center. She's the directing attorney down here in the 8th Judicial District. They estimate about 60% of family law litigants are unrepresented parties, and they're very concerned with the idea of specific pleadings in these issues, because, again, a lot of these people don't know what it is. They don't think of these things. Maybe they get attorney later, maybe they go through pro bono, maybe they go to ask a lawyer and they're talking to the ask lawyer and it's like, well, why didn't you do this? Well, good luck getting a pro per to understand how to file a motion to amend. They're fairly technical. I do believe it will increase motions to amend. With regard to the financial disclosure forms and the sanctions, those are both things that I am, actually, before I say that, I will say that I am, to some extent, a fan of the idea of specific pleading in what we would call a mish-off case, where we have cohabitants who don't have, who've held property together but aren't married and don't have a legalized relationship. Those cases come up from time to time. They may start occurring more, especially now that we have, guidance that allows for same-sex couples to go after some of these issues if they weren't specifically married, as we get to, frankly, my generation that doesn't get married, or at least not for a very long time. These cases are coming up more, and I do anticipate they will come up more. That those are difficult cases to identify in a notice pleading. It may not have to be specifically pled in the detail that fraud is pled in, but perhaps to say that we want pleadings that say, the parties moved in together, they had this agreement, they have not entered a marriage. Additional notice on that would be potentially helpful in identifying those cases. With regard to the financial disclosure forms, I wholeheartedly agree. I think you'd find that a lot of the section agree. We don't understand the financial disclosure form half the time. We're looking for places to stick, different things that don't quite fit. There's lots of things that kind of get wedged into places. I don't believe they're particularly helpful to the court as they are. They're often drafted incorrectly. There's often confusion about them. I can tell you in my office, probably 1 in every 3, we print the form as is with the numbers in it, and then we have to scan it and add an asterisk at the bottom that says why this is, inconsistent, or why this is in this thing, just so the court has additional information. These forms have historically been prepared by attorneys. I've heard a lot of attorneys say they'd like to go back to the AFC, which I think is 15 years old at this point, because they are complicated. I do believe that it would be beneficial to have a lifestyle analysis expert, some of our business valuation experts, some of these people who deal with the accounting side of divorce and have degrees in things like accounting and that sort of thing, go through these forms and recreate them in a way that will provide information and make sense. I don't know if the court believes that is a function of this committee or not, but I would encourage that to be done. I also do appreciate the idea for a stronger sanctions language. I think that this court is aware that family court has a hard time issuing sanctions. It's not our first thing. We're very lenient with that. And I think that there are pro pers and attorneys who take advantage to that, and it may be something that could be and should be strengthened. Legal Aid has also made comments on the idea of publication. They sent their comments. Stephanie wanted that to be stressed, I believe. That was something she brought up, the idea of alternative means before publication. My concern, to be blunt with that, is that I believe the case law requires publication. And so doing it together allows you to meet the legal standard if the other side doesn't come back and say, oh yeah, I'm here, feel free to serve me. The alternate means is to allow for texting or Facebook messages and that sort of thing, so we can give actual notice. But if we give actual notice and they don't allow for personal service, I believe publication would still be necessary, and therefore doing it together, although difficult and kind of a pain in the butt, allows for us to meet those goals without extending the time period necessary. The The other thing, my only other comment, unless the court has questions, is with regard to the issues on Rule 35 that the neuropsychologists have recently brought up. There are 2 additional rules that have been added to the family law section, 16.2.2 and 16.2.3. Those rules were to direct custody evaluations and minor child evaluations where there's a disagreement between the parents as to issues with the children, specifically to take those out of Rule 35, because Rule 35 has been historically the umbrella under which those were directed, although not particularly well followed. I would encourage this court, as it's thinking about the potential issues with Rule 35, to think about those implications with Rule 16.22 and 16.23 as well. I would note that part of the reason for moving those out was concerns about bias over children if parents were present for some of those examinations, and the issues with, frankly, psych custody evaluators being recorded over evaluations that take 2-3 months, or having an observer who may skew those results. However, there was an effort to continue to maintain those somewhat close to Rule 35, and so those issues need to be considered as well with regard to those 2 rules.
No questions, thank you.
Thank you.
If we can go back to Carson.
Thank you for all your work on the committee, Rachel.
Thank you.
Stiglitz, if we have some.
We do. Mr. Graham?
Thank you.
Good morning, members of the court. My name is Bob Jensen, and I am appearing on behalf of the Nevada Justice Association. As the court is aware, this is the largest organization in the state of Nevada devoted to litigation representing consumers and injured people. On behalf of the organization, I would like to say that we wholeheartedly support the changes that are being made to the Nevada Rules of Civil Procedure. It updates them, gets rid of problems, and for the most part are very much supportive of all the changes. We do have some concerns specifically with respect to Rule 35, and I'm mindful of Justice Gibbons' comment about no video recordings, and that's not on the table, but I wanted to just point out, coming from the trenches and having practiced in this area for 35 years, I've noticed a marked change in defense medical examinations in this state. It used to be occasionally we would see a defense medical examination report that supported, at least in part, some of our clients' claims. Now what's happening, and I routinely tell my clients, don't expect anything good to come from this. I can almost write the report myself, and in fact that turns out to be true time and time again. We're seeing preordained biased reports. They're cut and paste jobs on some occasions. You can see it clearly from one report to the next. They turn out to be factually incorrect. Our clients are coming back to us and saying, I did not do that during the examination, or I did not say that during the examination. And the problem that this raises, it's become so pervasive in this state, is that what in effect is happening is our clients are going off and being examined by a medical provider or a psychologist or whoever that's been hired by the defense, and there's no check and balance on this. They're being examined where even in a deposition we have the right to a court reporter or videotaping of what's going on. And then the doctor comes in and says, this is what happened. And so we have an unsophisticated Nevadan against a doctor, and in the battle for credibility in the courtroom, we're almost always going to lose that battle unless we have something to verify what really happened in that particular examination. This is particularly acute in psychological evaluations as well as vocational rehabilitation evaluations, where they're sitting down and talking, as one of the good doctors in Las Vegas said, for 2 or 3 or 4 or 5 hours in these wide-ranging discussions. There's no way to have any kind of a verification of what's being said and what conclusions are being reached in that situation. Just by way of anecdote, I handled a case a little while back where my client was injured in an accident. I believe it was their shoulder that was injured. The defense hired a local doctor who did, I thought, a reasonably decent, balanced evaluation. The defense was not happy with that. They went and hired yet a second defense medical examiner, and putting aside whether or not that's appropriate or not, This evaluator from Las Vegas came in and said none of it was related. I discussed this with the second evaluator, and he just said, this is just flat out biased. This is not accurate. The case then progressed on to an underinsured motorist status, and a local evaluator was hired by the insurance company. He came in and said, you know, the knee injury is related, the shoulder injury, I don't believe is related. The case progressed further. The knee became more of a problem to the point where it became a significant economic part of the claim. The doctor then reevaluated my client and then said the knee's not related. The insurance company representative in that case, the defense counsel, looked at this and said, this is so preposterous, I can't even use this in the arbitration. These are the kinds of problems that we're seeing. And I think it's particularly acute down south, but it's also very much alive as a problem up here in the north. For that reason, the NJA believes that the best way to deal with this particular problem is to actually, as well as have audio recording, have videotaping of these proceedings so that we can see what's going on. Audio recording of these examinations is only going to cover what's been said. Video recording is going to cover what actually occurs in the evaluation. And just briefly, to discuss, I appreciate very much the psychologists that are appearing before the court here to give their comments, but a lot of these problems can be rectified. We're not interested, there's no deep, dark conspiracy where the plaintiff's lawyers are going to grab all the test results and start testing our clients and get them to be boned up on the results. That's not really, I think that's a fear that is just unjustified. These results, the raw data and the testing materials are routinely disclosed in these cases. If there's a concern about audio recording, that can be done unobtrusively. If we're going to have an observer, the observer can be behind one-way glass. If there's a concern about videotaping, the video machine can be off so it's outside the presence and unobtrusive in the whole process. Psychologists, voc rehab people, neuropsychologists, these people are often testifying as to whether or not they feel our clients are malingering, whether our clients are in fact being truthful. And so under those circumstances, this is not a clinical situation where there's a doctor-patient relationship. It's really an adversarial situation. And under those circumstances, the people that are injured in this state, they should be protected by at least having some sunshine on what's going on so that we've got something recorded, we understand what's being said, and we also understand what's taking place in the examination. Thank you.
Thank you, Mr. Jensen. Would you like another Carson, Chief?
Yes, please.
Anybody else like to make a comment? Mr. Hayward?
Thank you, Judge. Good morning, Your Honors. Dan Hayward with Laxalt Nomura. I and Dennis Prince were nominated on behalf of the State Bar of Nevada Board of Governors Task Force to speak on behalf of the task force. I know my friend Dennis Prince is down there in Las Vegas with you today. 11 of us met in Reno and Las Vegas via teleconference on 3 occasions in order to review the committee's proposed changes and debate those proposed changes. There were members of the defense bar, plaintiff's bar, and some of us who consider ourselves somewhere in between. We each, of course, brought our own experiences to bear and our own viewpoints based on our areas of practice. But for the most part, we remained very civil and nonpartisan, I would like to stress, especially in this current day and age. We distilled our collective views, which sometimes differed at the individual level, into a consensus, which we presented to the court through a letter dated October 2nd. And I trust that Your Honors have and are able to review. Those comments are fairly voluminous, and I hesitate to stress any particular one over another, given that I am speaking on behalf of 11 of us. But Dennis Prince and I are available this morning to answer any questions that Your Honors might have about those comments.
With that being said, any questions reference Justice Strickland, do you? Thank you.
Very good.
No
Thank
questions.
you.
Thank you.
Additional from Carson?
Any other public comment in Carson at this time? No, thank you, Chief.
Thank you. We'll come back to Las Vegas.
Peter Helmet.
you, Your Honors, for allowing me the opportunity to address this court. My name is Peter Hellman. I'm a court reporting firm owner in Nevada. I am involved court reporting. In addition, I'm the designated representative of the court reporting firm. I wasn't going to speak today, but I did notice that there was a filing by the Las Vegas Defense League of an item on the website, and I felt it was important to address those issues. I'm here individually to support the proposed changes in the NRCPs as well as the current rules that are afforded under those rules, under the rules. I appreciate the court bringing up the issue of dealing with technology has changed since 2005, and we all have to adapt to those changes. I, as a court reporting firm, had to deal with a lot of issues. We are in a drastic shortage of court reporters in this state, as well as most states that we represent. With that, we have taken on, we have been conducting both stenographic as the rules allow. The rules are very clear that we're allowed to do stenographic, audio, and audio-visual depositions. We have been conducting stenographic as well as digital depositions for the last 10 years, conducting thousands of these depositions without issues. Only recently issues have been brought up by the defense bar, and they have been addressed within the letter that was proposed by them. We have felt that the shortage has become an access to justice issue within the state. We provide pro bono depositions, utilizing our services that we have attempted to bring our court reporters in and have not been able. And additionally, we use the same technology as most courts are using the JAV system and not using court reporters. We personally use the JAV system as well. I noticed here inside the court there isn't a court reporter. This system the court is being recorded currently, or this session is being recorded and will be transcribed, or the notes will be created. We adapted the same technology, availability, and the limitations that we currently have within the state.
Sir, do you have any certified court reporters working for your firm, or is it you just dealing with the JAVS type approach?
We do both. We are a court reporting firm. Typically in the state, court reporters are independent contractors. We pull from a pool, and the pool is as good as it is or as busy as it is. I must turn away on a given month dozens of depositions that I cannot get court reporters to attend. We have to use other technology just to be able to conduct these depositions. I notice a lot of people behind me have utilized or have defended or have been defending depositions that we have conducted using this technology.
Well, I think the key issue, the way I understand it, because I talked to the president of the Court Reporters Board shortly after this committee started, and they did a very lengthy public filing with us. I believe their position is under the NRS that only court reporters can swear witnesses at a deposition, certified court reporters, and notaries can't. And I know that's a legal issue that's out there to be resolved, but did you take a position on that point?
Yes, notaries are capable under NRS, I believe, 241, able to administer oaths. All our depositions are conducted by someone able to administer the oaths. Either those individuals conduct the deposition, or per NRCP 28 through 32, we are allowed to assign someone to actually conduct the deposition. We don't take depositions. Attorneys take depositions. We're the officers there presiding over the depositions. Being a court reporting firm, we follow every rule as court reporters. We are outside of, when we do digital, it's outside of court reporting. Court reporting is specifically related to stenographic. We are not doing stenographic, and they are aware of this. This has been brought up in the last legislature to try to specify court reporters, and it was not passed through the last legislature. And this committee also took into consideration, or the Rules Committee did take into consideration the Court Reporting Board's discussion or presentation, and still continued with the proposed rules, the modification of 28 through 32, as well as the current rules and federal rules allow these depositions to be conducted by audio, visual, and stenographic.
Right. There's a second issue, I believe, with the Court Reporters Board, and I'm bringing it up now since you're here, and we can get this issue vetted at the moment. Your second issue was that even if the Supreme Court entered a rule that notaries can do the depositions and all that. You don't have to be a licensed certified court reporter. The board feels that there's no licensing mechanism or any way to regulate the people, administer the oaths, or do the recordings, so therefore the quality or maybe of the report of the deposition may come into question then. So what's your thought on that?
This was addressed, actually, I believe, the prior rules committee to this one. They discussed, there's three primary associations that regulate recordings around the country. There's the There's the National Court Reporters Association, which deals with stenographic court reporting. There's the NVRA, which deals with voice writing, which is an option that's available federally as well as throughout most of the states. And then there's the AAERTA, which is the American Association of Electronic Court Reporters, Transcribers, and Transcribers. They have been around for the last 20-some-odd years. They are represented in the majority of states. It's an alternative. As the NCRA represents the stenos, the NVRA represents the voice, the AART represents digital reporting. They have a certification process. I am currently a CER, Certified Electronic Reporter. I went through training and I got my certification from them, and I'm a current member. In addition, there is a HECV, which is the American Guild of Court Videographers, which has also been around for 20-some-odd years, certifying videographers as it relates to depositions, that they meet the skill requirements and they're capable of maintaining a record. It all interjects into my responsibility as being a court reporting firm owner, that I follow the rules that are set forth in 656 personally. I believe that 656, the NECs, the NRSs, and the NRCPs make it very clearly how a deposition is to be conducted, how an officer is to swear in the witness, and how a transcript is to be produced. The page requirements, the fontage, things about all those things that are related to it. We adhere to every aspect of that. Every deposition or every transcript that comes out of my office, I personally sign. That it met the requirements that follows with 656.
So you support the recommendation of the committee that's been submitted to the Supreme Court?
Absolutely. I believe it's very important to be able to allow, especially dealing with access to justice. There's a lot of rural areas that court reporters will not. We have been trying to get court reporters to get into, even as close as to Pahrump, or into some of the outlying areas within Nevada. In addition, we do depositions within the courts in the jails and things of that sort, which I can't get a court reporter into it. We've been conducting those depositions. As I said, we've been doing this for almost 10 years now without any objections. And I want to address very clearly, and some of the issues that were brought up within their concerns is, under 30B3A, it says, how do you deal with competing transcripts and things of that sort? The official record is the audio and visual transcript, is the audio and visual. That is sealed, that is given with a courtesy copy of the transcript. All of our depositions are synchronized, which means that video and that transcript are synchronized in there. When you play that video, the transcript flows. If there's a discrepancy in the transcript, you fall back to the recording. The recording is the official record. Just as it is currently within the court systems, that is the official record. There's nothing that states within the rules or the statutes that you have to have a transcript. In fact, it says in there, it's at the option to have a transcript. You can conduct it by just audiovisual. The rules give the opportunity of the opposing sides or whomever to create a transcript from that recording. We make it very clear when we go on the record that this is an audio and visual recording deposition. The official record is the audio and visual. I'm spouting out verbatim because I've done thousands myself. And that enables everyone to know what is the official record. And it says transcripts will be created from this recording, not in addition to this recording. Some of the other objections, and I apologize, that were brought up were dealing with 30B3B, no remedies for parties dealing with malfunctions. We hold ourselves to a higher authority, in the sense of our licensure. Our licensure requires additional redundancies. We We have been dealing with the JAWS system since 2005, which is what the courts use. We use that as our basis of our recording when we do remote depositions. In addition to that, we have instilled at the request of our licensing body, that we have redundancy audio, independent of what we're recording. We have 3 levels of audio redundancy and 2 levels of video redundancy. I have conducted, as I said, thousands of depositions, and not one of them have I had an issue where we were not able to record a deposition or be able to have that recording after the fact. The last item that was brought up was 30B2, the 30B, I apologize, objections. There was a discussion to waive objections to the officer or the qualifications of the officer. All notices per NRC, and I always use this with clients, NRS makes it very clear that when you conduct a deposition, it says that a deposition notice must state the manner in which the deposition is being conducted. A deposition may be conducted by steno, audio, or audio and visual. Every notice that goes out with that 15-day rule is very clear in stating that this deposition is an audio and visual recorded deposition. It further gives the ability 5 days out to modify that. But it also says within the rules that any party can bring a stenographer or any option into there to add onto there with the 5-day rule. All we're asking is just to conduct this and to follow the rules as they currently state. Furthermore, when you say that there isn't the court reporting board brought to you that there isn't an authority to be, or there isn't a regulatory board maybe to regulate these, they have a proposed BDR, NRS 656B, which actually states that they want to take over the court recorders within the courts. And those court recorders be certified by the AAERT, which I'm a member as well. So for them to say that there isn't a regulatory body that represents the electronic recording, it's disingenuous, I believe. I think it's very clear if you read through 656B what they're attempting to do in order to have control over those recorders. Any questions? I'm more than happy. I tend to talk a lot.
Well, thank you. I kind of was doing this part of it for our committee, so that's why I'm asking the questions. But just an observation on the deposition of the proposals to switch from 15 days to 14 days on the notice to make it congruent with the federal rules of civil procedure. So that's a minor change, but that's one of them in there.
And then one other thing as well, when there is a point saying there's no regulatory body until the court or the legislature decides. I'm not as well versed, but I believe interpreters fall under the regulation of the courts. The courts decide what gets in there and what doesn't. It's not the court reporting board. It's not other outside agencies. The courts determine how something is to be conducted. And we feel that the court with what's happening around the country with courts accepting and digital becoming prominent because of technology, I think that the rules as they are written and are proposed are adequate in covering these issues. Thank you for your time. Thank you for your time.
Then we can call the next speaker. We'll take one more speaker, then we'll take a curt 5-minute break.
Good morning. Dennis Prince appearing on behalf of the task force appointed by the State Bar of Nevada. As the court is aware, the task force has delivered a letter to the State Bar, and I think Ms. Farmer has forwarded that along to the court. We have a couple of comments today, specifically regarding Rule 32A-D, regarding usage of deposition transcripts at a trial. The task force has outlined a position that we didn't think the rule was necessary, and that was the official position of the task force, taken through weeks of discussion regarding these particular points. But several of my colleagues, including several which are here and who have approached me over the last several weeks, have asked me to address a different topic. So in that sense, I'm here in a personal capacity. One of the principal concerns in a smaller personal injury case, or any personal injury case for that matter, is the use of a deposition of a treating physician who would be local and therefore subject to the subpoena power of the court and therefore technically wouldn't be unavailable. As the current rules are framed, Rule 16.1 and otherwise, there are certain treatment of treating physicians that they're given. And so I've been asked to discuss with you the notion that a non-retained treating physician, their deposition can't be presented at a trial in lieu of a live appearance, regardless of availability or being within the subpoena power of the court. Part of the reasoning and rationale for that is, number one, to streamline the litigation, to make it more efficient. But oftentimes, and typically these cases become so expert intensive, not only in short trials, but also cases that are no longer in the short trial program in front of a jury, they're exceedingly expensive and at times very cost prohibitive. It is common to have medical expert witnesses require $5,000 to $10,000 for a day, a half a day, or even a day's testimony to rearrange their schedule. And at times there's difficulty with court scheduling and having witnesses wait in the hallway, and this is something that I would say that I had, unfortunately, the unique experience of having expert witnesses wait the better part of a day before they can come and testify, and therefore now instead of $5,000 or $6,000 fee, it's a $10,000 fee. So I think in terms of the fundamental fairness towards the litigation process, and particularly in smaller cases involving consumers in the state of Nevada, that it would certainly be beneficial to allow the deposition transcript of treating physicians to use that trial, even if the treating physician is within the subpoena power of the court. Because otherwise it would be considered technically available and you wouldn't be able to use the transcript. So I think that would be an effective means to address that particular issue. So even though the task force, we took no position on it, in fact recommended not to adopt the rule, which I did also agree with, and in personal capacity after discussing this matter with members at the NJA conference and people who have approached me since that time, I think this narrow, limited exception to the rule makes not only fundamental sense, but substantive sense, but also is consistent with the rule-keeping idea of streamlining cases and where we're capable of it, reducing the cost. One of the problems is obviously the civil jury trials are dying. There's fewer numbers of them. In part, that is because of the sheer cost and expense of litigating these cases.
What's your thoughts on proportionality? I think, if I remember correct me if I'm wrong, the state bar was not in favor of proportionality.
We were not in favor of proportionality.
Why is that? I know Mr. Jimerson testified about that earlier, but that was kind of a big issue with this committee, and what's your thoughts on that?
The concern was that proportionality brings with it a whole other layer of analysis and a level of difficulty and a level of subjectivity in terms of how if we need access to information, and now you're dealing with proportionality in a particular case, it's a very difficult, and that now becomes another source of litigation and how to a contested issue, and it would be almost we think it's an unworkable standard. Someone who's dealt with that proportionality issue numerous times in federal court is not uncommon to be denied what would otherwise be a reasonable discovery request based upon alleged proportionality need. And then you keep having to go out and do additional work to come back and justify the level of proportionality. We felt that there are other provisions within the rule that gave the same level of protection by way of oppressiveness. You could deal with motion for protective order or other means within the rule itself that gave the same level of protection without adding that additional layer of ambiguity and confusion, which then is going to lead to a wide variety of other litigation. I think we're trying to streamline. I don't think that's the method to streamline.
When we were in San Diego, the court made a presentation on at the NJA meeting on the rules of civil procedure. And remember, your partner brought up the question to me was that he was concerned that there's too many experts designated in smaller cases, and anytime you designate an expert, that means you got to take a deposition, and there's a cap on depositions here as proposed in the rule. I think we have 10 per side, if I remember correctly. It seems like your position is kind of contradictory to his, or I'm misunderstanding your point.
Not necessarily on that. I thought proportionality was more regarding receiving information. Clearly, expert witnesses now derive civil litigation, and that's where the majority of the time we spend in terms of engagement, paying them, report writing, depositions, or otherwise. So I think Mr. Eglin and I's position on that particular issue is consistent. With regard to proportionality, I know he and I have had a number of discussions regarding proportionality issues, and I guess we're trying to avoid having another layer of obstacle, I'm just looking ahead and what I've dealt with in federal court of the continuousness of litigation, the frequency of the motion practice, and it leads to further discovery fights. I think there's fair mechanisms already within the rules that deal with those issues to provide protection to both sides, in fairness. I think that's what the committee, when we met, and we had a lengthy discussion on proportionality, multiple occasions. I think both sides of the aisle, plaintiffs and defense lawyers and others who represent even commercial interests, felt the same, that our rules were appropriately tailored to deal with the needs of litigants and provide the necessary protection without creating the potential for increased litigation. Proportionality will increase litigation. And then it requires, if you lose your motion, then you're going to engage in some level of discovery, and then you have to then go back and justify more discovery, the need for more information each and every time you want it. And in part, you're relying upon representations that it would be too costly, too burdensome, or too oppressive to obtain information. That's the issue. I guess if there's already cost mechanisms built in there for the party who wants that information to potentially have to pay for it if that's necessary. And also, the discussion primarily centered around electronically stored information. We're kind of past the day and age where we have multiple storage lockers full of information, but this information is typically readily accessible in an electronic format, and there's ways to handle that, and I know Commissioner Bullitt does down here, and the Commissioner in Washoe County also deals with these topics on a frequent basis about how to come up with ESI searches and the like, so that we can, all sides can gain access to information that is necessary for the case.
I have a question back to your proposal, and perhaps I misunderstood it, that you would not need to present a local person live at trial if they had been deposed. What do you do with the hearsay rule in that setting? I mean, it's one thing if it's a party or a party representative.
That's right. It would be an exception to that. That's why I talked about unavailability. I think the current rule as it's drafted is you can use retained and non-retained expert depositions at the time of a trial under 32 AD. Right?
If they're unavailable.
If they're unavailable, right. We're proposing potentially creating the idea to streamline litigation that if a retained, non-retained treating physician, regardless of availability, that's right. So it would be an exception.
So you would have to amend the Rule 50, the Chapter 50 of the Nevada Revised Statutes, because you'd be conflicting with the hearsay rules.
I think you could likely do it within Rule 32 itself.
Because we had some debate on that in committee.
Right. I think the entirety of the topic deals with the level of unavailability. That's the only time you could even use a deposition in that manner.
Right. Okay. So you're not saying it would be automatic. They would have to have other time commitments and so on.
I think that's likely true. But I think the concern was, it says, notwithstanding Rule 32A4, a party may use for any purpose the deposition of a retained or non-retained expert, even though the deponent is available to testify, unless otherwise ordered by the court. In my mind, the way that's currently drafted, that is an exception to the hearsay rule.
Okay.
That's how, if you read for any purpose, and typically the any purpose language has been used for a party-opponent deposition, and that can be used in an opening statement, it could be used at a trial, it could be used, for example, if a party's, and I've done this, if a party's sitting there at counsel table, read the deposition in lieu of calling them at the trial. And that is a permitted practice under the scope of the rule. So the way the rule is drafted, it already, Justice Pickering created the exception to, under Chapter 50, relating to the hearsay rule regarding unavailability. One last topic I wanted to address, I've been asked to address, and the committee endorsed certainly Alternative 1 to Rule 35. Rule 35 has seemingly received the most commentary as part of information. We certainly have heard from qualified, very well-respected neuropsychologists here in our state. But let's understand the practical reality of what a Rule 35 exam is. It's part of an adversarial process. It is not a normal examination to start with. The litigant is going to a physician or a healthcare provider, not of their own choosing, who they have no relationship with, who the adversary in a lawsuit has selected them to be evaluated by. It is certainly not a friendly examination. They're not there to be their friend nor to benefit them. But more importantly, what's critical is there's not even a patient-physician relationship even established by reason of the examination, and that's made clear. The examination and the results of the examination are required to be put in a report, which is not confidential. because all the medical records and the treatment and related to the injuries, that's part of a public proceeding. The psychologist or other medical care provider, commonly someone in the field of orthopedics, neurology, neurosurgery, otherwise, they're going to be testifying in a deposition and ultimately at a trial regarding their findings. The principal concern is there is no level of privacy in the examination in any event because of the report writing requirement, the deposition, which is part of a public record, as well as the trial testimony of a particular physician. And the concern is from someone who's been injured and is now being subject to a Rule 5 examination, there needs to be a balance to the playing field for fundamental fairness reasons. Because these examinations oftentimes take place over a period of an hour, or even in neuropsychological evaluations, multiple hours. One of the ways that these doctors, and this is a whole industry that I'm sure the court can appreciate. Think of all the consternation now you've had dealing with the treating physician rule versus the non-treating physician rule, and how experts are treated. Many of these experts that we see in cases routinely show up, and it is a substantial financial gain for them. They are voluntarily putting themselves in the litigation process for their own monetary reasons. And so the concern is it becomes part of a deposition. It's an inquisition. They're asking detailed questions about prior medical history, onset of symptoms, limitations, disabilities, and they've now had the benefit of reviewing voluminous medical records, deposition transcripts, interrogatory responses, and so now these questions can become very loaded. And now you have someone there who's they're nervous, they've never been through this before, they're now with a physician that they've never met before, and they're being asked very detailed questions. And how is there any way for either me or any other trial lawyer, for that matter, to appropriately ever cross-examine a Rule 35 examiner regarding their report? The biggest issue is the history taking. Oh, they told me the onset of symptoms didn't happen for 3 weeks as opposed to 3 days. They told me they've never had any prior problems, so now they documented that in a report, and now they're going to testify to that. Expert witnesses occupy a very powerful role in the civil litigation process, particularly medical doctors. They're cloaked with some level of credibility just by reason of their status. And there's no effective way to cross-examine the expert unless there's an audio recording of some kind. If there's a dispute as to what was said or how it was said, the audio recording levels the playing field to, number one, see how the question was asked, what the exact response was, and if there's any follow-up response. And that is, but it's also a way also for the provider, if there's a challenge to them to the report, the accuracy or the validity of the report, they can also refer back to the audio recording themselves to rehabilitate, yes, I asked that question, and this is how I asked it. Oftentimes, these physicians are summarizing or giving their impression based on what somebody said. It's not a verbatim transcript. It's how they process whatever the particular plaintiff said to them during the course of the examination. This is a way to ensure that there's a certain level of fundamental fairness and a reasonable way to cross-examine someone on the accuracy of their report, which goes to the validity of their opinions, which also goes to bias. And bias is always a fair area of inquiry at all times. And particularly, for example, and I was just talking to Judge Kadish, and we were talking, she referenced a moment ago, that police officers now wear body cams. And there's a reason for that. It's to ensure that there's a recording of the exact exchange between a suspect, who there's an encounter with, there's an arrest with, both for the officer as well as the person being arrested or detained. Similarly, there's dash cams now on both taxi cabs, buses, Uber, Lyft, and that's so that we can record accurately what transpires so there's no mistake as to the events that led up to a particular event, arrest, or detention, or otherwise. The privacy issues that were concerning to Dr. Kinsor, who I have used as an expert at times, I think those are more theoretical than otherwise. For example, testing data, the psychology community certainly is always worried about their testing data. But that testing data is going to be turned over to the lawyers, not to the other doctors. The testing data is stuff that we'll routinely request and demand so that we can properly cross-examine somebody who's tested or evaluated one of our clients. And so for that reason, it's not cloaked in some safe, it's going to be disseminated to people, including the opposing lawyers and opposing experts, and discussed in a very public way. So you're going to be in the, I understand, I would respect very much their ethical concerns and considerations. Those simply don't have the same level of import they might have in a private practice setting as they do in a forensic litigation capacity. And so for those reasons, we think that because these physicians have a strong financial incentive to participate as a Rule 35 examiner, and some people that we receive routinely, week after week, and they earn well into the 7 figures every year, we need to ensure a certain level of fairness. And Judge Williams had a case last year where it was illuminated, and I think it's well public knowledge that Dr. Duke is not the only one, but there's been others who have given inconsistently reported history given by a particular patient. And it's the only way that the only way we learn about it is through audio recording. I think that's a fair way to balance. The observer, that's another area of concern. I think an observer can be there, can be in a room and not participate, not have any indirect influence. And if there's a concern about that, then the examiner could stop the examination, report that, what's going on in the record, and if there's any undue influence, and the court can make an appropriate ruling that they couldn't go forward with the examination, nor could the examination be properly completed. So I think there's a number of protections that we could build in, including the practical use of the Discovery Commissioner at times if there is an abuse in the process to deal with this issue effectively. So we think both the Rule 30, the task force, I think almost virtually unanimously endorsed the alternative one to Rule 35. I think it's fair, it's reasonable, well considered, and appropriate. Thank you.
I don't know whether the questions are appropriate to direct to Mr. Prince or to Mr. Hayward. If Mr. Hayward is still present, maybe he could come up. I meant to ask some questions regarding your letter of October 2nd, but I couldn't find it. All this material, and I finally located it. Specifically, if you could, you have suggested language that would modify the rule NRCP 6. This is on page 2 of your letter, suggesting that by stipulation, the parties can extend the time for discovery, briefing motions, hearing a motion, trial. It seems like this amendment places in the hands of the counsel the control of the court's docket. That seems problematic, and I was interested in knowing what the thought was of your group about that, why you're requesting this.
I think it was to give some level of flexibility to the parties and the counsel more in terms of the briefing schedule and as we lead up to the hearing and the time for completing discovery without necessarily court intervention, more thinking preventing the amount of time that we have to go to court and the court has to deal with a particular issue, assuming it doesn't interfere with the typical administration of a hearing.
Well, but if you can move a hearing on a motion, or if you can move a trial date, the court has lost control of the proceedings. Is that what you're intending to do here?
Let me read the comment if I may.
Yeah, okay.
Dan, if you have a thought on that, could go ahead and...
Oh, thank you, Mr. Prince. Yes, Your Honor. I would note in the letter, let me read this. Quote, the parties may stipulate to an extension of time without court approval so long as the extension will not interfere with the time set for completing discovery, completing briefing of a motion before a hearing, hearing a motion, trial, or any other court-ordered deadline. So, Your Honor, it was our intention to actually avoid the concern that you just espoused there. Counsel can control on their own stipulating to extend time for various things, but not to the extent that it would, for example, postpone the submission of a motion to the court in the 8th Judicial District before a Monday hearing. But, you have to have a motion submitted and fully briefed by a certain period of time in that locale before the hearing, and this would not permit counsel to interfere with that deadline that is set by the rule. So, Your Honor, no, we could not unilaterally among counsel postpone hearings, postpone trials, or even interfere with the due date for submitted briefing before hearing. Only relatively mundane matters, so that we could take this out of the control of, stop burdening the court with relatively mundane requests for extension of time.
But it does seem like those extensions could result in an unintended consequence. What to counsel may be a reasonable extension bumps up against the court's ability to prepare for a motion or to prepare for a trial, or...
Well, for example, Your Honor, I recognize what you're saying. I think, and again, speaking for the committee, or rather the task force, if a motion for summary judgment has to be submitted 30 days before trial, but the motion is filed by, say, the defendant 90 days before trial, and the opposition is due within a particular period of time, those attorneys could stipulate among themselves to extend that opposition date without burdening the court with having to deal with that, paperwork, basically. It would not interfere with the court's order that the motion be submitted at least 30 days before trial. That's just an example, Your Honor. I understand, though, there are unintended consequences that we might not have anticipated, which is the case with every rule change.
Could you or Mr. Prince address your comment to NRCP 12 and the elimination of the language from the proposed advisory comment, and what your thinking was with respect to that edit?
Yes, Your Honor. Dan Hayward up here in Reno. Our concern there was relatively minor. We simply felt that the language in the existing comment came across to us as a little partisan, the word development, suggesting, for example, that the Nevada court should eventually evolve and adopt the Twombly standard, or the Ashcroft standard. Now, perhaps that standard should be adopted or will be adopted, but we just felt that the language was a little partisan, that's all, and suggested removing that.
And then could you take a look at the 60B comment, which is on the very last page of the letter? I wonder what the thinking was about striking a year and staying to 6 months. It'd be helpful to have your thoughts on the record on that timing issue.
Your Honor, I think Mr. Prince was more involved in the discussion of that particular rule, and I don't want to punt this off to him unless he's able to comment on that. Mr. Prince?
I am. No, I think the concern was that the 6-month time period adequately addressed the potential relief available under Rule 60B, that extending the time period for up to 1 year unnecessarily delayed the finality of the ruling. That typically, if there's going to be one of the grounds that is entitled to relief under Rule 60B, that should and will likely be known within the 6-month time period. And we were concerned about the ability of someone to come out and vacate an order, a vacated judgment for either side, that it would promote a kind of a lack of diligence, and there might be some exceptions created to that rule by extending the time period. The 6-month period is obviously an outermost window for challenging under Rule 60B under the enumerated circumstances, the time period for challenging an order or a judgment. We felt that was more than adequate time period. And we vetted this for the better part of an hour during the course of our discussions with the task force, and felt that the 6-month promoted diligence and being more proactive with the litigation as opposed to not, and that extending the time period was unnecessary and removed the level of finality that you would otherwise have to challenge the validity of judgment under those enumerated circumstances that the 6-month period applied to.
So you don't think we should line up with the federal?
We did, almost unanimously did not want that.
Okay, and we added some additional provisions in 60B, I think subsection 5 and 6, I don't have it right in front of me, but we had the one situation where if you're beyond the time limit, but maybe it's a void proceeding from ab initio, we now added suggesting that would the courts be able to consider setting aside a judgment under certain circumstances.
Yes, I think our concern was subpart B6, which was any other reason justifying relief. that created a very vague standard subject to a broad spectrum of interpretation and potentially reviewed by this court potentially, and that the idea of granting or obtaining relief from a judgment or an order was already properly articulated within the rule and didn't need to necessarily have that additional. So we didn't agree with the federal rules in that sense. We felt that the protections within Rule 60B itself were more than adequate and adequate grounds for challenging. Seemingly they've worked very fair and very efficiently for many decades in our jurisdiction. And we were particularly concerned with subpart 6, where any other reason that justifies relief, and just the breadth of that terminology would create a whole layer of litigation, potential review, and differing interpretations, and it would be a very difficult standard to work with. And that's why I think to remove any ambiguity and to maintain the clarity that we felt the rule already had, that's why we recommend a deletion of subpart 6.
Just, Mr. Prince, just on that, I think this is an analogy. It's kind of ridiculous, but this came up before the committee when discussing that. What if we have a situation where a hitman's hired to kill somebody, and the hitman, the person doesn't pay the hitman. The hitman sues and says, I'm owed $100,000 for this murder contract, files suit against the contractor, gets a judgment. If it's a default judgment, gets a judgment that more than 6 months expires, and would we be locked into situations where does that judgment now become final? Because it was properly served, it wasn't challenged, the 6 months expires. Without that escape valve on that last clause there, that was something I think the committee considered as one reason we need it.
So I think those, I guess, arguably within the technical confines of the rule, that would be a final judgment, no longer subject to modification. And I guess our principal concern was that kind of outlying extreme example wouldn't fall within the vast majority of cases, and beyond more than the vast majority, the high percentage of cases, it wouldn't be necessarily be applicable to. But also, you're also trying to apply the rules comprehensively to all aspects of civil litigants, and you're trying to encourage diligence with everything that we do, bringing motions timely that are meritorious, and we didn't want to create any new standard by which some dilatory action, depending upon the eye of the beholder who did the reading and who did the review, that could be problematic. And so we were very concerned about the wide variety of circumstances that might fall into that escape clause, subpart 6. And so I think we were very mindful of that. That's what our thoughts were.
Further questions? Seeing none, thank you, Mr. Prince. And one of the points you raised about doctors being loved by jurors, I had an interesting case where I had a Catholic priest testify for my client, and I had a psychologist, and to my friends in the psychology area, they loved the psychologist and they disliked the Catholic priest. So only me that could happen to a Jewish guy. Thank you. And there hasn't been a coup. The chief had a previous engagement at Boyd Law School, so as Associate Chief Justice, I'll take over now. And I'd like to know from those in the audience, how many folks would still like to speak? We've got some time left. We've got one over here, 2. Anybody else? We don't want to cut anybody off. 3, 4. Okay, I think we need a 5-minute break. We'll take a 5-minute break, and then we'll come back and we'll go for at least another hour. Is that okay with you,
Yes.
Justice Pickering? Yeah. We'll go till at least 1 o'clock. And my luncheon date, we can make another time.
Just go late, Mike.
Let me go tell them. We'll do this again. Please be seated. Thank you. Any particular order? Who wants to go first?
Thank you, Your Honor, and members of the court. I appreciate the opportunity to do this. My name is Aileen Cohen. I'm here on behalf of Las Vegas Defense Lawyers. I came actually to the hearing to observe, in light of the comments that have come about. I just wanted to make a few comments as well in response and entertain any questions. Hopefully I will have the ability to answer them. With regard to Rule 35, the one remark I wanted to make, because there's been a lot of commentary that has already gone on expressing many of the concerns that we have already put in the written comments, as well as what we've seen, is we noted the chilling effect that this could have on the side of the defense bar in terms of getting examiners. On a personal note, I have seen this happen. I have already had at least one examiner, and I've heard from colleagues of other individuals who have encountered physicians and other medical professionals who do not want to do examinations that are auto-recorded. I don't believe this is due to any kind of sinister or nefarious purposes on their part. I believe that they are just not comfortable on a personal, professional level doing that. We come from a state where we do not have a tremendous pool of individuals to work with to begin with. I already note that there are some individuals who believe that we are often using the same people over and over again. I don't think it's intentional. I think it's just because that is the resource we have. If we go ahead and allow this recording to become a mandatory thing and we do not entertain the options such as Alternative 2, you're leaving us with an even smaller pool, and we will be using the same people. And over again, we will be finding ourselves getting the same questioning over and over again at depositions and at trial, that the same individual has been used case after case after case, especially in light of the fact that they want to change the language so that we can only use individuals who are licensed here in Nevada to do IMEs as well. So that would be the one thing I'd want to say about Rule 35. I would like to move on to some of the other comments that have gone on as well.
Ms. Cohen, I just, now under Rule 35, as you know, there's 3 alternates prepared by the committee and submitted to the Supreme Court for consideration. I believe one, Mr. Young and Mr. Eisenberg, supported was alternate 3, where you'd have to go to court to set the parameters of the IME as to whether you can use a recording or a witness or an observer there. So I assume, is that what you're advocating for?
Actually, from the information that I provided to the court as part of our commentary, it was my understanding that it was Alternative 2.
It may be number 2, I'm sorry, because 3 was...
That was the neutral one, in essence.
3 said you could have
an observer, and I believe 2 was you had to go to court in order to get the recording.
I'm sorry, I hadn't transposed them. So alternate 2 is what you're proposing?
Yeah, that is what we have put in our commentary. Okay. So with regard to, and LVDL supports the concerns that the task force had identified regarding use of depositions at trial in lieu of live testimony. And so I'll just leave it at that. With regard to
forgive me, just to be clear, you support their position of using those depositions then?
I did not do a commentary in terms of support of using depositions unless counsel have stipulated to it. The position had been that we had expressed concerns about use of depositions in lieu of live testimony unless the parties had stipulated to it. And there were some concerns about being unable to, not having the rule clarified properly. Basically, I was just piggybacking on the concerns that the task force had identified.
Would you want treating physicians' depositions to be used even if they're available, if they're local, or are you opposed to that? Do you want them to show up?
I would think if the parties, The position that I was taking, and I did not actually discuss this with the other members of the board, but I think that they would probably be amenable to this. That is, if council stipulated and they were fine and they agreed together that yes, we can use this deposition in lieu of live testimony, then I don't think there would be any opposition. However, if somebody wanted an individual to be there to be able to cross-examine them, then yes, I think the issue needs to be addressed and the rule needs to be clarified so that a person who did want a live witness could have their concerns or their issues addressed.
So I'm trying to think how this would be worded. So you basically don't want that as a right because you want to be able to object to using that deposition if the person is available. So therefore, your process would be it can be used if stipulated to by the parties.
Yes.
Okay.
Yes.
Thank you.
So I think given the relationships that many council do have, that could work out. There have been other opportunities in terms of preparing for and undertaking trial where parties have to work jointly. I believe this is another opportunity where they can work together to streamline issues and testimony to avoid having to unduly take up the court's time.
How would you feel about a rule that says that it's presumptively permissible unless cause is shown otherwise? I worry that sometimes people withhold their stipulation just to run up the other side's costs or to be obstreperous. Why shouldn't the court be controlling this if it's presumptively permissible? But if somebody shows good cause, there's been some change of circumstance or additional information's been developed that warrants cross-examination, why not presumptively permit the video?
I think in terms of, Your Honor, in terms of the parties having been boots on the ground and knowing the scope of what they want to seek out of that witness and the testimony, then they would know whether or not they actually need the individual to get certain information or whether or not the testimony as it exists would be what they need at trial. And I think that if somebody did not actually agree or stipulate to something, it would be for a good reason in terms of trial strategy and not just to be obstreperous. At least that's the way I see it from my side, from working with other counsel who are preparing for
Well, I don't mean to disparage your approach to this, and I appreciate that, but all too often we see cases where folks have not been as professionally accommodating as yourself.
I want to return for a moment to your comment about 35 and licensure. The draft proposed rule talks about suitably licensed or certified as the expert, but the comment suggests that the person would have to be certified or licensed in Nevada. Currently, as I understand Rule 35 practice from my years of work, there's no requirement that the examiner be a Nevada licensed physician to conduct the examination. Is that the current state of affairs, that the person must be licensed in Nevada?
It's my understanding that somebody has to be either licensed or they can be provisionally licensed. They can operate under the license of a presently licensed physician.
So do you interpret the rule and the comment to allow that, or are you reading this as a change in the rules that would require actual Nevada licensure, full-on licensure?
My concern, and yes, the way I was reading it, was that it would be full Nevada licensure. That was my concern.
So it could be operating under the auspices of a licensed physician? Sort of pro hac vice, I mean, the analogous.
My concern was that a provisional licensing situation operating under a Nevada licensed physician would not be allowed, that you would have to be a full-on licensed physician, which
I don't think that was the intent, but
I hadn't heard anything to the contrary, so I wanted to make sure that was out there, and that was my concern.
Thank you for raising it.
You're welcome. And thank you, Justice. That way I was able to bring that out into the open, because I was concerned that that was the intention, but because nobody else was talking about it. With regard to one final thing, actually, and just since Justice Pickering brought me back to Rule 35. One of the things that several of the commentators had said was with regard to defense experts is they were talking about it being an industry and also it being involving substantial financial gain to the individuals who are involved, and that they play a powerful role. Those same things are things that, frankly, we could say about the individuals who treat plaintiffs. It is not unheard of that I encounter some of the same individuals who are treating some of the same claimants I see from case to case to case. And they are offering very similar opinions, and they are also offering some of the same information in their reports over and over again. It's not a one-sided opportunity. However, what is one-sided is my defense examination or my medical expert has one opportunity to look at this individual, whereas plaintiffs, treating physicians, who are also individuals who can be deposed and who can testify and who can formulate opinions and create life care plans and offer opinions not only about treatment but about causation, get to testify and offer all different kinds of opinions regarding that scope. And I get one opportunity at that. When you increase the amount of requirements and you limit the amount of resource I have in order to do that, you don't just harm me, you don't harm the insurance company, you harm my insured, you harm my client who happens to be an insured. And that is an individual who needs to be addressed in this situation. It's very easy for somebody to point a finger and say, you insurance company, you corporation, but it's not always somebody who is an insurer. There is oftentimes an individual who may be involved or who is involved, and they need to be considered as well. And so when we talk about police with body cams, well, yes, that is somebody who is carrying a gun and has the ability to use lethal force. When you talk about cameras being in this building or being outside or being in a bus or Uber, well, we're out in public then. But when you talk about this, the situation of being with a medical provider who conducts examination and asks you to disrobe so they can examine your body and do things that normally is not considered something that is appropriate for a visualization other than by a medical professional. Somebody who does that and has been trained and who has the experience to do that, that is different. So to say that somehow, wait, we've already given up so much in privacy, this isn't any different, it is different. And the same thing goes with the audio recording as well. And that when you have actual medical providers coming here and talking to you about the importance of the scientific basis underlying their findings, and especially given the role that plays in terms of Hallmark and other opinions that have come from this court, I think we need to listen to them about that. I will close just basically with some commentary that Mr. Hellman had made just in response with regard to the recording, the videography and depositions. Just simply this. NRS 240.063 requires that a transcript be certified. A notary cannot certify a transcript. That must be done by a certified court reporter. This was a very, very big issue for Judge Williams in a case we just had, or a colleague just had with him, where he ordered that a court reporter had to take the deposition in that matter. The certification was important because in absence of certification, that transcript cannot be evidence in a trial. So also, a notary cannot certify the accuracy of a transcript as well. Those things are things that need to be remembered. And just finally, Chapter 656.202 recognizes that court reporting affects the public health, safety, and welfare, and is subject to the regulation and control in the public interest. Videography is not. And yes, the Guild is there, and Mr. Hellman does comply with what the Guild says and does what he can to maintain the higher standard or the higher authority that he says the Guild is. But the Guild cannot do anything within the state of Nevada, as the state board has control over the court reporters. And again, until there is oversight, there won't be that same protection of the public health, safety, and welfare with use of videographers. The last thing also is that while there may be redundancy with regard to 2 levels of audio and 3 levels of video, if you have people who are talking over themselves, you have a court reporter who will say, counsel, I need you to stop. I can only take one voice. You know, you've all probably, you may have been there. I see a smile. And that is something that somebody who has a video recorder may not be able to do or will not do. And if somebody has something that's ruffling over a microphone, the microphone may be functioning, but the testimony may not be there. What do? We don't have anything in place. That needs to be in place. And thank you for this opportunity.
I want to return to another comment of yours. The letter is unsigned, but we have from Las Vegas Defense Lawyers, that's who you're representing.
Yes.
And the statement is that LVDL strongly maintains opposition to all of the Rule 35 proposals. And I took that to be all 3 of them, even Alternative 2. And then if I heard you correctly a moment ago, you were saying Alternative 2 would be acceptable to you. And I wanted to ask you to clarify that, if you could. I think Rule 35 has proven to be one of the most controversial of the rules, perhaps because we have these alternatives. But I'd like to know your exact position on these.
Yeah, and I apologize about that, Your Honor. Initially, it started out as, I guess I should clarify in that the opposition to any alternative that allowed for recording. But in terms of if recording is going to be an option, then Alternative 2 would be the alternative.
Okay, because Alternative 2 permits it, but it's on motion of the court, on motion and order.
Exactly.
Okay, so you would prefer not to have that option, but if you're going to have a rule that allows it, you would prefer Alternative 2 over the other 3?
Yes, Your Honor.
Okay, thank you.
Thank you.
Anything further, Ms. Cohen?
No, thank you very much, all of you.
Any further questions, Ms. Cohen? Thank you very much for your testimony.
Good afternoon, Your Honor. I'm keeping you guys from lunch here.
No problem.
But we appreciate all the committee's work and all of your guys' time. My name is Peter Goetz. I'm with the Legal Aid Center of Southern Nevada. My colleagues want to address some of the comments to our suggestion that publication only be used really as a last resort. We submitted a letter on Friday. It was a combination of a bunch of our attorneys in our office getting together and reviewing the rules. We understand that some of our suggestions are maybe reaching at this time, but we wanted to get that conversation started. For example, appeals from the Justice Court to the District Court. We have a lot of problems in the Justice Court with the rules as they are. We were hoping that this committee and this task force would have used this opportunity to address those rules, but we saw in early meeting minutes that that was not the case. And so we really want to bring that to the court's attention, that if we don't address it in this context, that there should be another commission, another opportunity to vet those rules. And I know, at least in the Las Vegas Justice Court, those discussions are already ongoing, and if it doesn't come through this process, hopefully it will.
Well, I think, Counsel, I think that's going to happen. It's just you can bite off so much you can digest. I think the committee and Justice Pickering and I agreed that let's get the NRCPs done. They're going to impact the Nevada Rules of Appellate Procedure immediately in certain areas, and certainly the local rules of the District Court and the Justice Court rules, but we understand your point, but we'll try and get these done and then see what the court wants to do next.
Perfect. And we're so happy.
This would avoid rule withdrawal by Justice Pickering and Justice Gibbons.
Justice Harris will take the next committee.
Oh, okay. Well, we look forward to working with you on that. Yes, Your Honor. So just getting into some of the specifics that we've addressed. First, at some point, we will represent at least 3,000 incapacitated persons in Clark County. We take a little bit of issue with the Rule 4.2 as it is written. That seems to say that an incapacitated person should not be personally served with process in a complaint or in a normal civil action. And it seems to conflict, at least in our reading, to the recently amended statutes that really say that in a guardianship proceeding where there's a petition and a citation, that those need to be personally served on the proposed protected person. And so we just wanted to highlight that for the court and hopefully have the court address that. We believe that even if somebody's in a hospital bed in a coma, that we can leave a piece of paper with them. And hopefully a family member will see that there needs to be some action taken on that person's behalf if they haven't yet been adjudged to be incapacitated and they're not yet under guardianship. Because we still have alternatives to guardianship if the protected person has done the correct planning. We also take a little bit issue with the comment that incapacitated persons are somehow more prone to violence against process server. We don't think that that is likely in an incapacitated person's case any more than it would be in someone who's not even alleged to be incapacitated. They could just be dealing with their own issues, but perfectly capable of making their own mental health decisions, their own financial decisions. So we would hope that the court would at least address that comment in there. One of the other proposals was to address consumer protection rules. We hope that this starts a larger conversation, but we really want the court to look at our proposed subsection H, which some other courts have and other jurisdictions have adopted. And that requires that you're suing somebody and you're relying on an instrument, a writing, that be included with the complaint. We are a notice pleading state. Without the exhibits being attached to complaints or even reference, we may file a motion, and I have done this in a case before. I filed a motion before the district court and said, my client was not a party to this contract. And the other side came back and said, well, I don't have to produce the contract. I only have to allege that a contract exists and your client breached it. And the district court judge ruled that, hey, you're going to have to make a discovery request once discovery opens to find that out. And that was costly for my client because then we filed immediately motion for summary judgment, and lo and behold, there was no contract. And to maybe cut off some of those motion practice.
Was this in justice court or district court?
District court. Actually, it was a business court case.
Really?
So, yes. And if the court would like, I provide a briefing and citation to you to review. But in that, the court felt at least that she was constrained in what she could do at that point because of our notice pleading standards. It also helps consumers and self-represented litigants know what really is at stake in the litigation if you have to produce the contract and the papers that you rely on. So if anything, court, we would hope, would seriously consider adopting provision H into Rule 9. Last thing I want to talk about before I turn it over to my colleague about publication is electronic filing rules. We have proposed eliminating, for the purposes of filings for declarations made under penalty of perjury, that we eliminate the requirement that the piece of paper be printed off, signed, scanned back into the system, and then filed with the court. For example, the bankruptcy court here in the state of Nevada allows the /S to be used, as I think our rules allow too on pleadings and other papers. But the court allows it to be uploaded to the electronic filing system. But it also requires that once it's uploaded, that there needs to be a declaration that's signed, handwritten somewhere else. So that would allow the proper person, litigant, to subsequently print off the document and have a handwritten signature on that.
Can I ask you a question? I recently read the Justice Court Rules of Civil Procedure for Las Vegas Justice Court rules. So they're local rules. My recollection was there were some provisions in there for pro se litigants that excluded them in certain areas from electronic filing. Am I right, or did I read that incorrectly?
Your Honor, I'd have to go back and look specifically at the local rules in Justice Court. And maybe you recall if there is one? It seems like Commissioner Bulla would know.
Commissioner Gold, you want to address Justice Gibbons?
Absolutely. Good afternoon. There are local rules in our EDCRs that prohibit at the present time pro se litigants from being able to e-file. We are working on those rules currently in our committee to revise them. In fact, I've actually given it a shot, so to allow access. So we are working on the issue, but currently, yes, they cannot use the e-filing system.
Well, this issue is on the Access to Justice Commission agenda for November 9th, specifically to address.
And we wanted to raise it here now, Your Honor.
We had a number of conversations with Judge Kishner and others to resolve that issue and to change that, and quite frankly, move the direction toward the federal approach in terms of allowing electronic filing by ProPERS and others and streamlining that process.
We wholeheartedly support that effort. I think
I believe the Access to Justice Commission does too, and if it isn't addressed, we'll be making a proposal to address it.
Yeah, on that issue, the committee originally, even at the pure district court lawyer-filed pleadings, we were trying to address to cut down the waiting in the queue issue that's gone on and to have simultaneous electronic submission, filing, and service subject to a later strike if the document was improper in the judgment of the clerk that later reviews it. And I hope that we can move forward and also address the issues that you're addressing here with Justice Court and pro se access. I mean, we've come of age electronically, and there's tremendous cost and time savings that can be accomplished, and I think we really do need to press forward as much as we can. I think there's a lot of support for that. I want to echo Justice Gibbons' comments. In general, there are only, the committee had to finally narrow itself to the rules of civil procedure and those that absolutely necessarily had to be amended to do this project, because otherwise we would never have completed this task. But the failure to do so signifies nothing. It is not a disinterest or anything like that. It is, we need to stop here, and then, for example, the 8th Judicial District Court, and Judge Bulla knows this as well as I do, that the local rules are in conflict with some of these new proposed rules. There's going to have to be some changes going forward, and I'm grateful that Justice Hardesty is willing to take the baton from here on out.
Well, we want to make sure that our guided survey, or I forget what it's exactly called, but our guided system with Tyler, it works for not only filings in justice court, but filings in the district court, is my understanding of that. And so when we're talking about this globally, the Nevada electronic filing rules, of course, are the umbrella rules for all courts. And if we can address that in this context, or at least raise it and bring it to the forefront now, we just see it so often in our self-help centers that self-represented litigants are being denied the ease of accessing our courts. It's tough enough for them to
navigate on their own anyway.
Right. And our office does our best with the help of the community, with the help of the court, to address those needs. But each barrier that we place upon these litigants, especially maybe in protective order situations too, where there's the family court overlay, we're delaying that justice to them as well. And in those situations, it's extremely important that they get access to justice when they come to us, and we can't be putting barriers where, well, you got to go print off the paper, sign it, and then file it again, and hopefully your family court judge can consolidate everything and move it forward as quickly as possible, which I know they do, and we get them the help they need. But if we can reduce one more barrier, the more access to justice these self-represented litigants will have. So if there's no other questions.
Any further questions?
Nope.
Thank you very much.
My colleague will talk about publication.
We're ready for that.
Thank you, Your Honors.
Good afternoon.
I'm Sonia Tomo with the Family Law Self-Help Center. I work for Legal Aid. I'm a staff attorney. I appreciate Rachel Mastel mentioning the directing attorney's comments. Stephanie McDonald, she could not be here today. I did, however, want to clarify and address a comment that was made about publication, and I'm just specifically addressing Rule 4.4 today. We do understand that the publication option needs to be retained. At the moment, however, everyone, there's only two ways to serve, either personal service or publication. I have seen firsthand how difficult it is for self-represented litigants. And so our comments are related to that. We would like publication to be used only as a last resort. There's reference to court-ordered service. However, there is not any specific examples or even guidance as to what that means. We had done a survey of other jurisdictions. Many jurisdictions allow service by certified mail, return receipt requested with restricted delivery as an option. That many jurisdictions offer posting at the courthouse. We did even see that in Alaska they offer posting on a court website. So we explored those options. The reason for our comment and on Rule 4.4 in Peter's letter, this was addressing that issue.
Any comments?
Thank you
very much. Thank you. Any further Commissioner?
Good afternoon again. Thank you all for listening to all the public comment, and I just want to briefly make a couple of comments, and then I'm happy to address any of the questions you may have. I thought it was important, and I was somewhat nominated by my subcommittee to be up here and make this comment, that proportionality flows through all the rules. It is a critical component to the change of the Nevada Rules of Civil Procedure. We actually already have proportionality in our rule under NRCP 26B2, which talks about discovery necessary for the needs of the case. So it's critical that the proportionality language remain in the rule. It governs the electronic discovery references in both Rule 34, the sanctions for failing to disclose electronic discovery in Rule 37, and it really works hand in hand with the concept of claims and defenses. And while I appreciate the commentary about the concerns of expensive litigation as a result of instituting proportionality, I hope in almost 12 years I've seen both sides of the issue on many of these issues, and I truly believe it will be beneficial. It will streamline cases, make them more efficient, and hopefully encourage the lawyers to really litigate the case before them. That's what I'm hopeful of. So the subcommittee, we went through a lot of analysis. This was not just Commissioner Bola. This was a collaborative effort. And I cannot tell you how impressed I am with the Chair, Graham Galloway, all the hard work he did. Every member of that committee worked so diligently. And proportionality was discussed, and it was debated, and it really was thought to be the right time for this change to our rules. So I wanted to make that comment. I was asked to make that comment. I am happy to address any of the other concerns. I do want to say to the members of the medical community, we are listening to you. We do care about what you have to say. It's important to us that we have a workable rule. And the rule itself, even with the rewritten and proposed language, still has the flexibility for the court or the discovery commissioner to look at an individual case and set parameters. And I will represent to the members of the community here that I have done that when necessary. We understand that the tests are copyrighted and they cannot be distributed. We understand that there are provisions ethically that require the raw data to be transmitted from one professional to another. But these are already efforts made under the rule, and I do not believe the proposed revisions will change any of that. The rule still allows us flexibility. The one significant change of the audio recording for 90, I hate to stick with any given percentage, but I would think for the majority of cases will not be an issue. When it does become an issue, if there is a concern, myself or the court, Commissioner Ayers, all of us would be able to address it and make sure we put parameters in place. Our concern is that we have integrity in the process. And Rule 35 is a litigation tool. So we need integrity in that process. But I am happy to address any other concerns or questions, at least as they relate to the discovery rules.
I just have one general question, Commissioner. With the changes that are made, would that put an onerous burden on you as the only discovery commissioner for what you do in particular, aside from the other Aaron Truman's job? Are these changes going to create a burden on you where our incoming Chief Justice may need to speak to the Chief Judge and see about a second discovery commissioner that does the same type of stuff you're doing rather than what Aaron Truman does?
Well, I do appreciate Erin Truman. She covered my calendar this morning so I could be here, so I should thank her publicly for that. I think we're going to see these issues. We already see these issues. I understand our community is growing. I think long-range planning is very appropriate, and certainly we can address these issues. I don't believe the rules changes as we've proposed them is going to add any increased burden. In fact, I'm hoping that it will give guidance to the lawyers that they can actually work out some problems and will have guidelines to be able to address some of their issues.
Well, your services are very valuable to the community and to the court system, to the parties, to this court. And I just want you to promise that if you need some help, that you'll ask for it. And I know that Chief Justice Givens will make sure, and Chief Judge Lindeville will make sure that you're okay. Because we care about you, Bonnie. That's what it comes down to.
I appreciate that very much.
You do a heck of a job, and I know it's a tough job.
Thank you. I'm happy to address any other questions.
Commissioner, just one quick question back to Rule 35. I know Rule 35 covers both physical exams and then psychological exams as well. My recollection was when we were discussing this in committee, the ratio of physical to psychological, it was somewhat skewed more in the physical side of these exams. In your experience, could you give us a rough idea on those requests so the court might can understand the issue further?
I think probably 80 to 90% of the examination requests are for physical medical exams. We have a very limited number of psychiatric type exams that are requested in a litigation setting where a lawsuit has already been brought. So Rule 35 really pertains to those types of exams. I would say, very limited number that I have to deal with. The neuropsychological are probably the more prevalent exams because of the brain injury cases. And those require special parameters to be put in place. I think the changes to the rule will certainly allow a court or a discovery commissioner to take into account those special types of examinations.
And again, for the psychological examiners, I know one gentleman's still here present today. The subcommittee, Ms. Myers, is proposing additional commentary under Rule 35 for the court to consider. You'll be submitting that to us that maybe address some of the concerns that were raised here today. Is that correct?
Yes, it is correct, Your Honor, and we're very mindful of those concerns. And I just, if I could do anything, it would be to stress to the public that we did read your concerns, we're aware of them, we're mindful of them. We want to have a rule that works. that's flexible, that will work for 20 years hopefully to come, because that was our goal. And so we want to put the parameters in place that will allow that to happen, but we will include specific language to explain that in certain types of examinations, such as neuropsychological, psychiatric, or other psychological examinations, that it may not be appropriate to have an observer present. Recording may not be appropriate, and that the court may set the proper parameters. And hopefully that will clarify the concerns. But that commentary comes with alternative 1, which is the alternative that the committee has proposed.
Okay, thank you.
Anything further from
the commissioner? No, I don't.
Thank you.
Thank you very much.
Anybody else need to speak? Way in the back. Why don't you come forward?
Good afternoon, Your Honors. My name is Chad Butterfield. I'm from Wilson-Elzer, and I am here to give comments in follow-up to our letter that was submitted on October 12th. I'd like to just provide some additional commentary on some of the rules. I won't go over all of the rules and our comments that we included in our letter. Rule 4.1 on waiver of service. We're in favor of the incentive portion of that rule, but the sanction component of that rule has some potential problems, especially in the insurance defense context, where you may have a defendant who has been sued, has not yet tendered to his insurance carrier, has not been assigned legal counsel to represent him or her, and then receives a request to waive service, doesn't know what it is, doesn't respond to it timely, and is subsequently subject to sanctions for failing to accept the waiver of service request. We're already seeing litigation by sanction in the 8th Judicial District. I think this would have the potential to increase that, or at least encourage that. So we believe the better approach is to maintain the incentive component of that rule, but to remove the sanction component of that proposed rule. With respect to Rule 16.1,
how would you enforce it in the absence of the sanction provision?
Enforce the acceptance of the...
Yeah, you've asked that it's be pulled out. How do you enforce that? I'm not entirely sure.
Well, the waiver of service is not mandatory. This under Rule 4.1, it provides an opportunity for a plaintiff's attorney to request that the defendant waive service process. And if that request is... So what we're asking for is that the sanction component of that be pulled out, and the rule maintain just the incentive component, which is the additional time to respond to the complaint. If that request is made and it is ignored, then the plaintiff's attorney would be responsible for waiving service in the ordinary course, just as it is under the current system that we have. So there would be nothing to enforce because it's just a request. There would just not be a sanction that would be attached to a denial of that request, or even an uninformed litigant who's unrepresented by counsel who doesn't know what it even means and what is potentially at stake.
Okay. Thanks for the clarification.
With respect to Rule 16.1, we have a few comments. 16.1A1A3 refers to relevant medical providers. It's an undefined term that's very subjective and is going to be subject to different interpretations by plaintiff's counsel and defense counsel. To address that, we propose having a definition or some guidance in the advisory committee notes that would clarify who the relevant medical providers are that are referenced in this proposed rule. Rule 16.1A1D provides 30 days for a later joined party to make its initial disclosures of witnesses and documents under 16.1. Under the proposed rule, it's 30 days after being served or joined. So if you have 30 days and then that party has 21 days to answer, it's only 9 days from when they've answered the complaint to when their disclosures will be due. There are some cases where that might not be enough time. What we would propose is triggering that 30-day deadline from the time to answer instead of from the time of service, which would give adequate time. If you look at the time that a party would have if they were the first party to answer or respond to the complaint, they would have 30 days to attend the early case conference and an additional 14 days after that to make their disclosures, 4 to 4 days versus 9 days after answering for a later joined party. Under Rule 16.1A2D1, again, this is a rule that contains an undefined term that could be ambiguous. It refers to ancillary treatment that is not contained within a treating provider's medical chart. Ancillary treatment is undefined, and again, I think could be subject to different interpretations from defense and plaintiff's counsel, leading to unnecessary motion practice, and we would ask for either definition or guidance in an advisory comment to that subsection of the rule. Rule 16.1A2D2 is an extension of the FCH1 case with respect to whether a treating physician is required to issue a report. Under this proposed subsection of the rule, provides that a treating physician will not be deemed a retained expert merely because the witness reviews documents outside of his or her medical chart in the course of providing treatment or defending that treatment. And that last part, or defending that treatment, it goes beyond the scope of the FCH1 case, which addressed only medical records that the treating provider reviewed in the course of treating that patient. We anticipate a scenario where after disclosures have been made, expert disclosures have been made, an attorney could supplement or could provide medical records to a treating provider who would then review them in defense of his treatment, his or her treatment, and that would make that medical provider still exempt from the report requirements, lead to unfair surprise. Rule 23B, we do have an objection to the aggregation of the individual claims for all potential class members for purposes of district court jurisdiction.
Why is that? I mean, that's designed to get the cases into the district court where they're better equipped to handle them than in the justice court.
It is, and in February, this court issued an opinion, Castillo versus United Federal Credit Union, that took the opposite approach.
I get it. So this rule would change that.
It would change that.
So why is that a bad practice in your view?
Well, we do have, as the Castillo case noted, it's unique in Nevada where the justice courts have jurisdiction over, or potentially have jurisdiction over class action claims. There are economical reasons to be in justice court versus district court, as well as reasons of economy. It could be a much faster and less expensive route by litigating a class action in justice court versus in district court. So
do you know of any class action that has ever been litigated in Nevada in justice court?
I did not research that, but I'm not aware of any off the top of my head, Your Honor.
Yeah, I think it's a little problematic. I'm familiar with the Castillo case, but I don't know. It's a policy question.
Well, and we do, as we pointed out in the letter that we submitted, the higher ground lien cases may have been appropriate for litigation in justice court versus district court, and would have been a much more cost-effective and time-effective venue to, or jurisdiction to litigate those cases versus in district court. And just a couple of others. Rule 30.
Would you, before you leave that, if justice court did not have Rule 23 and authorized class actions, would you agree that then this aggregation would be required?
I think I would agree that, and but again, that was in the Castillo case. That was the point that was made by the court that distinguished all the other cases in other states because of this unique factor that we have in Nevada, where we do have at least the potential for a class action to move forward in justice court.
Just observation, I think that Justice Baker and I both were on that case with Chief Justice Douglas, but I think that part was dictum in the case because the holding was you could go to district court because there was an injunctive relief sought, so it was kind of an extraneous discussion. Maybe we shouldn't have veered off into that, but I appreciate your point of view.
Well, and it is an interesting issue too. I mean, it highlights one of the unique aspects of being in Nevada.
Right.
With respect to Rule 30, just one minor point on Rule 30A2A1, which limits depositions to 10 per side. This does not allow for custodian of records depositions, which are very common when a party is required to obtain records, and they're not accompanied by the declaration authenticating those records.
But couldn't the court expand that? You know, if you have these perfunctory depositions from like a custodian of records, wouldn't the court still have the availability of the commissioners to say, okay, that doesn't count against your 10 because you need to get these records? And all
They would, and that would require a motion. So it would require motion practice and potentially an opposition from, I wouldn't anticipate a lot of opposition on a motion like that, or potentially even you could do it by stipulation. Rule 32A5, we've heard some comments on this rule earlier from Mr. Prince. We do object to the use of, or the expansion of the use of depositions at trial to include non-retained, or retained and non-retained experts, and especially with respect to treating physicians who may be deemed non-retained experts if they're properly disclosed. We don't know until 21 days before close of discovery who the non-retained experts are going to be, which treating providers are going to be designated as non-retained experts, potentially. In theory, they don't have to be disclosed until at the latest 21 days before close of discovery. We would have to treat every single treating provider deposition, not only as a discovery deposition, but a trial deposition. We've heard testimony about how expensive Rule 35 exams are and the costs, the industry that supports.
But wouldn't they have to be designated initially in the 16.1? Or?
No, they don't. Under the rule, under 16.
I mean, the proposed 16.1, the new changes to it, I thought, and correct me if I'm wrong, but I thought all that information has to be disclosed up front, and certainly you would know a treating physician, assuming they were treating at that time.
Theoretically it does, but under 16.1, under supplementing the disclosure, non-retained experts, they don't have to be disclosed until not later than 21 days before the close of discovery. So under Rule 26E, there is an affirmative duty to supplement timely, but in practice we see that doesn't always happen and doesn't always get enforced. And I've been on the other side of cases where a party has disclosed a treating provider as a non-retained expert on the eve of close of discovery, and it's been upheld. It's been allowed.
The commissioner upheld that? Or?
Yes.
Really?
Yes.
Okay.
Even after.
So your point is that you can't risk having a depot of an ostensible treating physician who's not yet designated. You have to treat that as a full-on trial witness depot under this rule.
Yes, and so it requires
It amplifies the expense and time and laboriousness.
I mean, I've deposed a neurologist who requires a 2-hour minimum at $1,500 per hour. When I deposed him, he said this was halfway through the year. He said he'd been deposed 90 times that year. It's expensive. So 2-hour minimum, when you are adding to that, not just the discovery component of it, but also preserving for trial, you're probably going to double that expense. It's expensive, it's front-loaded, and this is in contemplation of cases that probably will never be tried. And it's a cost that is probably going to be borne more by the defense bar than it is by the plaintiff's bar, because I've never seen a plaintiff's attorney depose a treating physician. It's always been a defendant. I've never seen one. It may happen, there's probably circumstances where it does, but overwhelmingly it's the defendant who is deposing the treating physician. So there are a number of potential issues that this proposed subsection of 16.1 that we object to. I think that's all I have, other than what we've already identified in our October 12th letter. Unless the court has
And by the way, we did get your letter. We appreciate it. It's thorough, and everybody has received it and has read it. So,
Any further questions?
Yeah.
Thank you very much.
Thank you very much.
I don't mean to point. I just wanted to make sure that Peter knew I was calling on you.
Good afternoon. If I may address the panel in support. My name is Lars Bangen. I signed in late. I just wanted to address some remarks that the person from the Las Vegas Defense League did raise. One was that sprung out right at me is her funny comments about the microphones. First of all, the court deals with that all the time. Secondly, I did preside over depositions, and I did admonish people not to talk over each other or scream or speak up. And I have had no problems with that. Also, there's multi-channel audio recording, so you're not only picked up by one. I'm probably not only picked up by this very microphone, but also to a certain extent if they're not muted your microphones. I just have to choose that channel and bump up the volume to be able to hear everything that I say from here right over there. I think that is a non-issue. The other thing, it is true that under court law, notaries cannot the transcripts are not certified by notaries, but again, the transcript is not the official record in an audio and visual recorded deposition. The audio is. And therefore, I don't know what the problem is. They can make a transcript if they so choose. They can bring a stenographer if they so choose. It's not like this is anything that just comes out of the blue. It is noticed as an audio and visual recorded deposition. If they have a problem with it, they can bring a stenographer, and then they can deal with that. By the way, accuracy, if they bring a stenographer to an audio and visual recorded deposition, they will be charged about 50 to $1 more, 50 cents to $1 more a page. And we did ask the court reporters why that is, and they said, because we have to be 100% accurate. That is kind of strange. We rely, and they say it is the gold standard, that the court reporter takes everything down verbatim and 100% accurate. Why do they require an extra charge if there's a video or audio recording? If they are, because they have to be.
Reporters regulated on charges where they set certain rates for depositions. If it's expedited, then it doubles the rate. Or if it's overnight, that changes the rates and all like that. But I thought it was pretty standard. They charge an appearance fee to go to the deposition, and then whatever the rate is per page like that. And I thought they pretty much all did the same thing.
Correct, but if you look at the actual, that's what they disclose on their website most of the time. But if you look at the actual bills, if it's an expert, if it's a medical expert, a technical expert, or if it's an audio and visual recorded deposition, they will normally charge an extra charge per page.
Because it's...
For the medical and expert, it is because there's extra work. They have to look up words, and That's very understandable. Audio and visual, the response that we got out of the court reporting community is because we have to be 100% accurate, and I'm paraphrasing here, obviously.
I understand what you're saying. Thank you, but you answered my question.
Then she brought up the case in Williams' courtroom, and Commissioner Bowler can probably say more to that than I ever can. It did arise out of a case, two specific cases that were in front of her, where the defense leagues argued that since there is notation on the notary's website that notaries cannot conduct deposition or cannot do depositions, that means notaries cannot swear in witnesses. That provision has since been removed after we have asked if that statement is still accurate. The notary board has removed that statement from their website. So it was never to be intended on there as far as I understand it. It was still a lingering link that was probably obsolete after the 2005 revisions of the NRCP.
Right. Sir, I might let you know that issue was thoroughly discussed in the committee, and ultimately I think it might be a legal question there, and the statutes that this court will have to decide. But,
absolutely.
But I just want to let you know we did go through that in detail.
Yeah. The other thing that was raised was that we are not regulated, and I found it very interesting that the court reporting board did bring that up too. We in fact have asked the court reporting board to set up a subcommittee to regulate this industry, and they have repetitively said no. The reason is probably the makeup of the court reporting board, which is 2/3 court reporters. So,
did you have a letter from them saying that they don't want to regulate you, or how did you find that out?
We brought that up in their meetings.
And is there some sort of record on that you can give to the Supreme Court? Can you file that for us with their response or whatever, that they didn't want to regulate you, just so we have that on our record? If there's a piece of paper that says that, I know we'd be interested in that.
Okay, I will try to get that. I know that those are recorded stenographically, and I can try to get those, at least one of those.
If you just get that and maybe send it up to Carson City under ADKT 522, which is these proceedings.
Okay.
I know we'd like to see that, if that
Okay.
exists.
Yeah, absolutely. Any other questions?
Any other questions? Thank you very much.
Thank you.
Yes, ma'am.
Good afternoon, Your Honors. My name is Jennifer Parks. I'm a registered nurse. I'm here as an independent consultant that works primarily in Nevada. I consult with attorneys, and I sit mostly in a consultant role. But in that, through the course of the last several years, we've had opportunities to observe the Rule 35 exam, and that's the reason for my comment today. I didn't come originally to speak, I was just going to observe, but I feel compelled to offer just a different perspective, as my firm has had the opportunity to visualize and participate as the operator of the audio recording device. So we were doing both, visualizing there as well as recording. And during that, which it's admittedly been only a few instances, but I would say 100% of the time, we were surprised by what we observed. Every physician has their own style, and I imagine that we were requested to go and approved to go because they might have been notorious offenders. So granted, and I do not think that our observation is fair to put a blanket statement across all physicians that operate and conduct Rule 35 exams. So I want to state that first. But anecdotally, I would like to express, because we were there, perhaps an example of why it would be a good idea to make this change where there could be both an observer and a recording. In this case, it was a doctor who was actually treating the patient quite kindly, and I'll say client, if I may, because it's not we didn't establish a nurse-patient relationship, and the physician didn't establish a physician-patient relationship either, so it's the client. And the client was there to have her knee was the primary body part that was injured. And the reason that it was so beneficial to have the recording as well as the visualization was that as he went to examine the knee, he first got in the way of the nurse observer, so he blocked the view where we had to get up and step to the side just to see. Again, unobtrusively, not speaking, not disrupting, but actually we had to physically move. And during that, he is asking the patient something that is unrelated to the knee. Just a course of conversation, being very cordial with her. And as he's doing that, he's manipulating her knee. And we noted that she winced, and she also said, ouch. But he did not ask her any questions about pain. And later in his report, and you can see how it lines up with the audio recording, he writes no complaint of pain. Well, he did not question her about pain or ask, but how that didn't match up with what was going on. So if it had been audio recorded, you wouldn't have caught her visual, her face with the wincing. You would have heard her say ouch, but you wouldn't have known why, and you wouldn't have known what he was observing at that time or what he was manipulating. So just one example, I think, that of why a both and would be beneficial. I would like to assert that it might be wise, as you're making these changes or proposed changes, that an observer who has some medical training would be beneficial. I think, one, because we're nurses especially, but even if it's not a nurse, we are trained to not only assist a physician when we're used to watching exams and even being a silent observer, we know what we're seeing, but the patient also feels very comfortable usually in front of a nurse, both in what they would say and if they would need to disrobe. They're used to that anyway, even though this is not a medical exam like it is in private practice or when they have a relationship. It needs to be a licensed person who's used to participating in a physician's, in an exam type of setting. The last thing I think I would just say also is, as I've sat and listened to these comments here, I've touched on it, but I would just like to reiterate it, that when we go there, we're not practicing nursing. We're using our nursing knowledge, our skills, our training in observation, but we're not establishing a nurse-patient relationship, nor are we there to change the outcome of that exam in any way. We just want to report on it so that there's a clear and accurate and fair, accountable report of what's gone on. Likewise, the physician's not really practicing medicine. They may provide diagnosis, but they're not prescribing and generally not opining what follow-up treatment should be done. Perhaps there are occasions for that, but that's not the norm. They're there simply to report on the standings of that patient, how they present that day. Any questions?
Just to briefly, so what you're advocating is that if there are observers, they need to be qualified observers.
I think it would be most beneficial. I don't know that requiring it's still nice for the patient to feel, the client to feel that they have someone in their court in terms of just someone who's there, but I think a qualified person would be the most beneficial to give an accurate report of what transpired.
What do you think of the hypothetical that was presented where you invite the spouse in who is committing the abuse? Is that an appropriate observer?
I would think that is not an appropriate observer.
So how do you screen that? The rule says observer. If it's presumptive, how do you screen that?
I'm not part of the committee, of course, just part of the public. But off the top of my head, my colleagues elsewhere, it's typically an RN that does it, but I don't know that putting that requirement in might be too cumbersome. And so I don't know that I want to assert that that should be done, but as a nurse, I feel that it would be a goal to attain.
But if the alternative that's adopted is one that has the judge making a decision on the guardrails surrounding these examinations, that's a factor the judge ought to be thinking about, don't you think?
I think that would be wise. And then it's at the judge's discretion
Yeah.
as well.
So if you have a presumptive situation, we're not really sure who the observer is. It could be anybody that defense counsel or plaintiff's counsel, in this instance, plaintiff's counsel decides to send in there. But at least that would be a factor that would have to be taken into account.
Yes.
And what is your view, given your profession, of the comments made by the professionals here that having an observer present or even audio recording inhibits the truth?
I believe those comments were made, the ones I heard, solely from a neuropsych evaluation perspective. And I haven't read the studies, nor did I hear that they were cited. I'd like to look at them myself before I offer an opinion about do I agree with them or disagree with them. But I feel that if the client were in agreement that they had someone there that they felt was to be independently observing, but sent by their counsel, then I think if they were agreeable, then isn't it up to them, their level of privacy that they're willing to give up by having someone else observe? That's a little different than what you ask about the accuracy, though, of how they might respond. And without looking at studies, I don't know that I have a strong opinion about that. I'm used to patients and clients being forthcoming, generally because I tell them I'm a nurse. Sometimes they tell you far more than you ever wanted to know, just simply because they feel comfortable. If they knew it was a nurse observer, would that help? It might. And that's, I think, a good question to ask.
You make a good point about studies. I don't know if we were supplied any studies. Is that right, Justice Pickering? We do have those?
We have some.
Okay.
In the written comments.
Yeah, okay, I'll look for that then. Thank you.
Oh, thank you.
Any further questions, nurse? Thank you, nurse.
Thank you.
Peter, can you be brief? Very brief. You're the only one who's talked twice, so.
Those who know me. Just really quick, since the LD Las Vegas Defense League spoke and I didn't have a chance to go, really quick transcripts. Currently, the courts that use JAVS, we have, by being a court reporting firm, as well as being a digital court reporting firm, we get calls from the courts to transcribe the depositions, or excuse me, the testimony. And we are not required, there's nothing in the statutes, nothing in the rules that say you have to be a court reporter, you have to have this licensure.
This is for court proceedings.
For the court proceedings.
So aren't depositions different, though? I think that was the point that...
Well, they were saying that all transcripts, I apologize, all transcripts have to be certified. And this is what they tried to bring up to the last legislature, and the last legislature said no. It's just a back way of getting what they want. So as I said, and there are cases where the laws are very clear, as my opinion, I'm not an attorney, I apologize, that, and as well as the rules, it says there's times that you don't need a transcript. So if you're doing a precipient witness and you just want to get some information, you want it on the record, we swear in the witness, which deals with my point two, the witness is under oath, the witness testifies, and they can make a decision from that. The court had ordered, I believe, in some of the rules under 30 that the court prefers the audio and visual depositions or during trial to be played, not read through a transcript. And that's where that becomes important. And some of our clients do not need a transcript. They know the case is going to close or it's going to settle. They just need to do some depositions, and it's a cost savings for all parties. I can address questions. I'm trying to be really brief. I know we're really late.
Yeah, it's 1:30.
Okay. The other one dealing with...
just one more comment, please.
One more comment?
Yes.
I have to do it in two ways, but I have a disability that physically limits me from being able to use a sonography machine. there is no way that I can pass the test for sonography. That's why I just chose as being an electronic recorder. We have, and unfortunately, Mr. Bong and Lars, when we went to I personally went to the court reporting board. I'm part of it. I go to all I've gone to all the meetings and we've suggested this. Ironically, the court reporting board does not record their meetings with a court reporter. They use an audio tape recorder. So to get the meeting minutes, I will have to ask for them to give us the audios for the last 4 or 5 years, and I would have to be able to pull it up. Contrary, he wasn't privy to that. He did not know that they don't bring the court reporter to their own court reporting board meetings. And if I just have 30 seconds to address something?
I'm looking at the clock.
Okay. Dealing with Judge Williams, the case that was brought forward, the rules are very clear. It says, unless the court orders otherwise, a deposition may be conducted by standard audio and audio-visual. Judge Williams decided in this particular case, he did not want it to be audio and visual. It wasn't a blanket statement as to all. The court has the discretion. Each court has the discretion whether to do it or not to do it. Thank you, Your Honors.
Thank you very much. And there was no second hand, so you may next time you did. Yes, ma'am. Come forward, please.
I'll be incredibly brief.
Okay. No second hand, so.
Christian Morris here. I was on the State Board Task Force, but I'm here in my own capacity, and I just wanted to respond to a couple of comments that were made. The gentleman from Wilson-Elster brought up the fact that as a defense firm, he's the one who takes the depositions of these treating physicians. And if you look at the scope of the way we're kind of changing the rules, the limit is going to be to 10 depositions. And so I myself, as a plaintiff's counsel, have taken depositions of my treating physicians. And if I know that I can use that deposition transcript at trial in lieu of their testimony, because the people we're talking about are emergency room physicians, people that saw them at the urgent care, all of these people that we have to kind of, quote, parade in order to get our evidence on, we have to pull them away from their jobs to do so, and it costs us a significant amount more to bring them to trial than it is to pay them for their deposition time of about an hour. Now, I've never been required to pay the 2-hour minimum. I'm required to pay them the amount of time in which I take their depositions. And so streamlining the process for allowing treating physicians who are in the community, if it's presumptively said, hey, you can use their transcripts unless something comes up, then I am going to be much more motivated to do that and to streamline the process and not steal them from their practices because they're not our experts. They are just treating physicians.
Counsel, there does seem to be a disconnect, though, between the time of notifying of the treating physicians and the deposition. I presume that you would support the idea of requiring disclosure of treating physicians earlier so that those decisions can be made.
Absolutely. Any treatment.
I mean, they're pretty well known, aren't they?
They are. They go into our 16.1s. Anyone who's treated them, we've gathered those records usually in the demand phase and put them right into a 16.1 in the beginning.
Yeah.
So there's certainly not any unfair surprise, and the treatment's already laid out in their medical records.
But as was pointed out, the rule only requires the disclosure 21 days before discovery ends. Is that true?
So you can always supplement, but I think it's getting taken out of context of who we're talking about. A treating physician is someone that they're seeing, and we have a duty to supplement. If they see a new doctor, we have to list that new doctor.
Sure.
And if we want to take that doctor's deposition, frankly, though, if we list it late on, the amount of treatment they've given isn't going to be significant enough for us to depose them.
Yeah.
Therefore, we're likely going to have to bring that treating physician at trial simply by the context of the time in litigation.
I didn't mean to interrupt your other points you wanted to make, but I did want to ask Ms. Beulah, Commissioner Beulah, I've been under the impression that treating physicians would be disclosed and designated earlier than 21 days before discovery. Am I wrong about that?
They are, Your Honor.
So where did that?
Morris is correct. The citation to the changing the rule was taken out of context.
Okay.
It says a non-retaining expert who is not identified at the time of the initial expert disclosure subsequently disclosed in accordance with 26E. Sometimes the plaintiffs have a new treating doctor that they don't know about.
Okay.
Or they have to see somebody new.
In that case, as long as there's a treating doctor, you can disclose them up to 21 days before the close of discovery.
Yeah.
So that the other side can take their deposition. If you don't meet that requirement, then you have to move to reopen discovery to identify them. So all treating doctors who are known at the time of the initial expert disclosure deadlines absolutely have to be disclosed.
And as they are treating the subsequent treaters, they're going to be testifying, they're going to be designated as supplemental designations.
That's right. You have to supplement under 2060.
Sure.
So when they become known, you have to do the disclosure. If it's too close to the close of discovery, which would be prejudicial to the defense side, obviously, then they'll have to move to reopen, and we'll probably have to move to trial date. But this provision of the rule does not contemplate that you can identify every expert treating doctor. And by the way, I do not allow minimum of 2 hours in depositions. So, just so the record's clear on that.
Okay, I'm sorry for interrupting your comments.
No. That's all I had on that point. And then, just one thing I wanted to point out is I was looking through all of the information and comments that were submitted. Dr. Eckhoff is not here today, but he is a neuropsychologist who does a lot of work here in the community. And he submitted his comments in which he is opposed to having anyone in the room or any audio or visual, but in the same note admits that he does allow for it. He said he is fine with it, that there are legitimate concerns from plaintiff's personal injury, that he's confident in the way that he test takes, and that he has allowed even employees of the attorney's firm to be in there. And so I think it was interesting, and I just wanted to point that out to you, that in fact he doesn't have any opinion that it would in fact make the plaintiff act differently or lie. He says he's confident in the way that he handles it. And so I think that I just wanted to highlight that because it wasn't here for public comment. I was interested to see if he would come and kind of explain more of the comments that he put in his letter too as well, because I think that really shows it's a kind of a practitioner decision as opposed to, hey, this would ruin our practice in the process.
Anything further?
That's it.
Any
Sorry
other
to take
questions?
time so late.
Thank you so much.
Thank you for your time. I appreciate it.
Chief, can I make just one comment before we close, then, like that? The court had anticipated at the beginning of the proceedings today at 10 that Todd Reese, who's a staff attorney that's worked with this committee from day one and has hundreds and hundreds of hours of work in it, would present an overview to the audience and to the 7 justices of what the committee has done and where it needs to go from here. I spoke to the chief about that at 10, and when he noticed how many people we had here to testify, he wanted to jump into the testimony. So I know Mr. Reese is still up in Carson City listening to this, so the justices will have an opportunity to talk to him when they meet and discuss this further then as well. So just want to let everybody know that.
Now I will ask Justice Gibbons and Justice Pickering, are we finished with public comment so that I can say that this matter is submitted, or should I leave it open? No. And there's still time if somebody wants to write some more comments, is that correct?
Correct.
Okay, and the next time we meet, is that public that we're going to meet again to actually conference on this?
Yeah, I think it will be,
October 29th.
29th. The 29th. I just want to make sure the record's clear.
It will be discussed very soon.
Okay.
You have the date?
But if there are any further written comments, I think they should be submitted ideally by October 29th.
Okay. Everybody understand that? Well, the 5 other colleagues of Justice Pickering and Justice Gibbons, we can't thank you enough for what you've done, and it's just a fabulous, fabulous process. We're trying to do it in the criminal area, and we're not as successful as the two of you have been. Justice Douglas and I are doing it, and sure enough, Justice Gibbons challenged me, and he wins, I lose. So, but thank you. This matter will stand submitted, and thank you, everybody, for attending, and have a wonderful, wonderful weekend.